1, 2, 3. Testing 1, 2, 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode, The Gavel Falls, Jenn Kamp's credibility crisis. I have now obtained the audio of the hearing that was held in the 3rd District Court in Salt Lake City, where Judge Faust is the assigned judge in the litigation that is ongoing between John Dehlin, OSF, and Jenn Kamp. This hearing is over 4 hours long, and I'm not going to make you wait until the very end to hear what is likely the most important thing that was said during the course of this entire hearing. At the very end of the hearing, Judge Faust had some choice words which he addressed directly to Jenn Kamp, and here they are.
Frankly, I'm just going to be very candid. I'm having a challenge trying to decide how much I believe you. I'm having the challenge trying to decide how much of your response and your actions, this manner and the way that you've conducted the discovery and the responses, the filing of your motions, etc., is based upon ignorance and lack of understanding of how to handle these things by not being a lawyer versus taking actions or steps to not provide the information or not make it available. You generally judge people based upon the things that they say and what they do. And the severe inconsistencies in your position in responding to things causes a lot of concern. Frankly, I don't see a great deal of candor. I don't see a great deal of forthrightness.
Where, though?
In providing, and we're not having a discussion.
Sorry.
I'm just telling you my thoughts.
Okay.
In weighing your believability. Okay. Okay. So I struggle with your information. I struggle with the things that you've done, and I struggle with the way that you respond. Frankly.
Now, all I can say is that if you are a party in a case in front of a judge and the judge is directing those words to you, that's not a good sign. That is why tonight's episode is called The Gavel Falls, Jenn Kamp's Credibility Crisis. And now that you've heard what the Judge Faust, told Jenn Kamp directly at the end of the hearing, now I'm going to play the entirety of the 4-hour-plus hearing so that you can hear why it was that Judge Faust said what he did to Jenn Kamp at the end of the hearing. And those comments will be included at the end of the hearing as well. I just wanted to make sure you didn't have to slog through 4 hours to get to the best part. This is a completely unedited version of the hearing with 4 exceptions where I have bleeped out the name of the innocent. And basically, that's me all 4 times. I have bleeped out my name. It will be very obvious where I'm bleeping it out. I am not editing anything else out of the record. So I want to let you know that about halfway through, there's 5 minutes where the judge takes up another case with a lady who has appeared in his court who wants to have her name changed. That takes about 5 minutes. I'm not editing it out because you are going to hear everything, and I don't want there to be any kind of allegations that I have edited anything out of the record in order to skew it one way or the other. This is the raw audio, with the exceptions that I've mentioned of me bleeping my name out. As a bit of an overview, the judge is first going to spend some time making absolutely sure that he has ruled on every single motion that Jenn Kamp has brought before him. This is likely in response to the motion that she filed to have Judge Faust disqualified because he wasn't addressing her motions. That was one of the reasons that she gave for wanting him disqualified. That motion did not work, as I reported on the last episode, and now Jenn Kamp is back in front of Judge Faust, along with John Dehlin, OSF, and their attorneys. After Judge Faust makes absolutely, thoroughly, mercilessly sure that he has indeed dealt with all of Jenn Kamp's motions that she has brought. He then takes up the 3 motions that are scheduled for hearing on this day. The first one being OSF and John Dehlin's request for attorney's fees. Now, the judge had already ordered that attorney's fees be paid. The attorneys then had submitted a declaration of the expenses that they had undergone that should be reimbursed to them as attorney's fees sanctioned against Jenn Kamp. And so this is more of a housekeeping function just to have the judge go ahead and sign off on the order for the full amount. The second motion has to do with the issue of whether Jenn Kamp has waived her attorney-client privilege by referencing and replicating so many times elements of her conversations with her attorney, and a similar motion is before the court with regard to her husband as it relates to the spousal immunity statute. The issue there being whether she has replicated so much of her conversations with her husband as to effectively waive the spousal immunity. And finally, at the very end of this is the big motion. This is the motion that is being brought by OSF to the judge that based upon Jenn Kamp's spoliation of evidence. Now, spoliation is a big legal word that simply means that they're alleging that Jenn Kamp has deleted evidence, hidden evidence, or otherwise failed to comply with the request for production from OSF and John Dehlin's attorneys, or to abide by orders of the court ordering Jenn Kamp to produce certain documents. You'll hear all about the details in the hearing itself, and it is at the end of that hearing and that motion that Judge Faust tells Jenn Kamp what it is that I have already played for you. My understanding is that since this hearing was held on April 23rd, the judge has ruled on the motion regarding attorney-client privilege waiver, which the judge granted to OSF, finding that Jenn Kamp had indeed effectively waived the attorney-client privilege, at least regarding communications with her attorney that are along the lines of what it is that she disclosed, and the judge made a similar ruling regarding Jenn Kamp's waiver of the spousal immunity with her husband by doing a similar thing. And the ruling, I believe, was similarly restricted to those things that Jenn Kamp had intentionally disclosed. It is just possible that there are some of you out there who do not have a full 4 hours to devote to listening to this. And so if that describes you, I'm going to suggest that you fast forward to the 2 hour and 49 minute mark. That's where the spoliation motion begins. So from the 2 hour and 49 minute to the end, that will take only about an hour and a half instead of over 4 hours. Now, let me remind you that that 2 hour and 49 minute mark is not from the beginning of this podcast. It will be from the beginning of the recording as I play it for you here in just a few seconds. So if you're ready for the most remarkable hearing that I have ever heard, that maybe you have ever heard, strap on your seatbelts, grab some popcorn, because here we go. Here's the audio from the hearing in front of Judge Faust, held April 23rd, 2024. Play the tape.
Kamp, case number 230900882. Will the parties please make their appearances for the record, if you would please? Let's go ahead and start.
Good morning, Your Honor. Shane Gostis on behalf of John Dehlin and Open Stories Foundation, along with my co-counsel, Jenn Kamp.
Thank you. Please.
Jennifer Ruth Kamp. I am pro se.
Thank you. And we have an individual who's appearing via WebEx by the name of Clint. If you would please go ahead and turn on your camera so you can be seen, as this is a public hearing and everybody is entitled to see who's participating, who's observing, etc. Okay? So please turn on your camera so you can be seen by us as well. Now, I'd like to accomplish a lot of different things today, if we can. Okay, first and foremost, we are formally now on the record. You've made your appearances, and we're going to cover a variety of different things that we have to do. First, and this may come as a surprise for some of you, I would like to set trial dates with you today. This has got to come to a conclusion. We've got to get off the treadmill of motions, counter motions, motions, counter motions, dragging out discovery's issues. Let's get the matter done. It's time to bring it to a conclusion. So that's the first thing that I would like to do. Second, I would like to take the opportunity to go through and make sure that Ms. Kamp motions or any items that she thinks are unresolved or haven't been ruled upon are clearly brought to the court's attention, and we can resolve those issues if there are any that are outstanding and not completed. Third, I would like to go ahead and resolve the other issues that I noticed up, okay, for the hearing today. And lastly, if there is not any opposition from either side, there was a recent motion that was just recently submitted and given to me. I think I saw it yesterday for the first time, to go ahead and handle and deal with that. And finally, I would like to have some conversation with Ms. Kamp about the rules and the procedures and the processes in order to make this matter go smoother for everybody going forward. And maybe we should take that up first. Now, Ms. Kamp, I know and I'm fully aware that you are representing yourself. I'm aware that you've hired counsel and they've left for whatever reasons and no longer represent you, and then you hired another counsel to file a most recent motion which was ruled upon concerning whether I should remain on this case or not. And then he withdrew out of the case immediately after he filed his motion. And so at present, you are pro se. There are some things and procedures and processes that you need to be aware of. First, the fact that you represent yourself doesn't allow the court to give you any different consideration or to give you any different set of rules to adhere to or to apply to, because of the fact that you're not an attorney and you're not necessarily qualified to practice law. The law says that you are to be held to the same standards and you are to know the same sets of rules that apply in this case. And that's applicable to everybody, okay? And the fact that you choose to represent yourself is fine and you're entitled to do that. But you can't rely upon or try to claim ignorance of the rules or the issues in order to try to get around the rules that have to be applied to you and to all parties equally. Okay? Now, second, it's not the court's job, responsibility, or obligation to educate you about the procedures, the rules, and the processes. Okay? I'm not your counsel. I'm not supposed to do that. Okay? I can't be seen to be giving any kind of favoritism to one side or the other. And if I bend the rules for you and to try to help you or to educate you, in my view, that's improper. Okay? Now, we want to get some procedural things kind of cleared up for you, okay? And I put some of that information in the last memorandum decision that I sent out for you that hopefully that you've read, okay? First and foremost, okay, if you bring a motion, only have one topic, one item, or one issue in that motion. Okay? Don't put 3 or 4 different things combined in the motion. Okay? Next, you have to allow the proper amount of time according to the rules. And again, I can't educate you on the rules, but they're there in the books. You can look at them to allow them to respond. And then you get a response. If and when the motion has been fully briefed, okay, a party has to submit a request to submit to the court. Notice to submit, request to submit, something of that nature. That's what you have to call it. That triggers, out of all the thousands of documents that we get, notifications to the judicial assistants that a motion is ready to be put together and given to the judge to decide whether or not it should be heard or to be ruled upon. Okay. There's also a requirement in Rule 7 that says that unless a request to submit has been given, the judge doesn't have to even see it. He doesn't have to rule on it. It can sit out there for a year. It can sit out there for 3 years, and we do not have to deal with it until the party gives us notification that it's ready to be heard, okay? So I know you've kind of had complaints and issues in the past that we're not hearing your motions or we're not getting set to be heard, et cetera, et cetera. That's in part why. That's only a small part, okay? So I'm here to tell you, my clerks are instructed, as all clerks are, they are not to give me, not just yours, they don't give me anybody's notices and motions until those notices to submit are put in place. I have over 1,400 cases, and we have to follow these procedures in order to maintain some order in the way we go about our work, okay? So we'll just never know unless you tell us that a request to submit is there. But the request to submit that you give has to contain that information that I outlined for the benefit of the clerks, so they can go look in the files and pull the appropriate documents and put them together for me. If you don't have that information in your notices to request to submit, I've instructed my clerks to reject your request to submit. It's not their job to go through and look through thousands of documents filed in a particular case to find the right ones that apply to a particular motion. That's counsel's obligation, and that's what the rules require, okay? So if you don't have your request to submit, if you don't have it properly followed what the rules say, it's never going to get to me for a hearing or for a decision. You just need to be aware of that, okay? Second, not all motions are required to be heard in a hearing by the court, okay? I believe only Rule 56, a motion for summary judgment, if it's going to result in the dismissal of a case, are the parties sometimes entitled to have a hearing. Now, if the law is clear, if there are issues that aren't in dispute on the motions for summary judgments, then it may not be necessary to have an in-court hearing. So the fact that you don't get a hearing in front of me doesn't mean, okay, the fact that you don't get to have a hearing in front of me doesn't mean that I didn't hear understand and read your motions and make a ruling on the merits of your motion. Okay? I cannot give hearings on every single motion that everybody files in every case. It is just not physically possible. Okay? Now, I know you may want to get the sense or the impression that you're getting your day in court and your day to be heard, and that's fine. But it's not always the equivalent of having a hearing in front of the judge. Okay? We do it by the way of motions and make rulings and so forth thereon. So I wanted to explain that to you because your conduct in the way that you've been filing and handling your motions and your pleading support has been challenging for the clerks, been challenging for the court. I know it's been challenging for counsel and with and when and how and what to respond to. Okay. Now, the other situation is here as well. When the court makes a ruling, that's it. It's done. The ruling's over. Okay? You don't get to revisit and re-request the same thing again multiple times from the court. Okay? There is no such thing as a motion to reconsider. That doesn't exist in the rules. No such thing as a motion to reconsider. Okay? So when I've made my ruling, that's the end of it. When and if you believe it was wrong, you're entitled to appeal it. That is your avenue of relief if you think that a wrong or incorrect decision has been made. When the case is over, you can appeal it. Okay? That's the way it's handled. I'm not going to go back and keep dealing with your motions and your same motions and your same motion and your same motion. For example, you've got one in there we've dealt with 3 times. 3 times. And you've gotten the answer at the same time, and you don't seem to want to take the answer. I'm not trying to get mad at you, but you're not going to get your way all of the time. Okay?
Can I respond?
No.
Okay.
In this case, somebody's going to win, somebody's going to lose. It's okay? And that's the same thing in every decision, on every motion. On every motion, one party's going to win, one party's going to lose. The solution isn't to keep asking for a new motion to get a different answer on the motion. Okay? That's all I need to say about your motion practice. Now, I'm not cutting off your motions. I've considered barring you from filing any more motions without the court's consent because it's getting to the point where it's almost abusive. Okay? But I haven't, and I won't at this point in time. Okay? Now, in regards to proceeding forward, there are requirements that you have to meet. Okay? If you don't meet the requirements, there are consequences for those, either in the form of sanctions against you by failing to produce or provide the documents, which can result in the evidence being excluded at trial, or it can result, as we have pending here today, various motions to have you pay for their attorney's fees for what it is that you've done on bringing unmeritorious motions and not complying necessarily with court orders. Okay? So what I'm saying is there are consequences. We do have pending in front of us today a request to exclude certain information or to instruct the jury to make a negative inference against you for your failure to provide the information. Now, I know you two guys may have a dispute over whether or not you did or didn't provide it. I get that. I understand that, okay? But when the call is made as to whether you did or whether you didn't, that's the call. Okay? So, that's all I necessarily need to say in regards to the procedures. We're not going to bend the rules. We're going to follow the rules, and you got to comply with them. Okay? Counsel?
May I respond?
Why? I'm just telling you what the rules are that you need to comply with. There's
Right, well,
there's
I'm just
no
addressing
response.
the motion that you said I submitted 3 times.
We
It was
will-
because
We will get to your motions in a minute.
evidence wasn't given to me 3 times.
We will get to your motions in a minute.
Okay.
I'm just saying, these are the rules, that's what's going to apply. If you don't comply with them, there can be consequences, one of which is, I never hear the motion, I don't take it up. Another one is you're sanctioned for fees and costs. Another one is the jury is told to make an inference against you because you destroyed evidence and didn't produce it.
Right.
Okay, I'm just giving you the ground rules that apply in this arena, okay? And so we don't need to go over those again going forward.
Correct,
And
yeah.
frankly, when and if decisions are being made that don't come out your favor, it's not being done for any bias, prejudice, or personal motivation against you. It's just, these are the rules, this is what applies, and this is the decision that goes into effect. Okay? Now, let's talk about setting some trial dates, and then we'll get into the motions, and we'll give everybody a chance to have what's on the ground. So, counsel, I do not remember, and I did not look, do we have a jury trial in this matter? A request for a jury trial?
Yes, Your Honor.
Okay, so we need to pick a jury that's going to take the morning of one day. Next, that being said, how long do you anticipate is needed for trial?
We were estimating approximately 8 days, but we would request 10 just to be safe.
Okay, I'll ask you some more questions about that in a minute. How long do you think trial would take?
I am uncertain. I do not know.
Let me explain to you some of the things that we'll do for trial. And we're going to give you a standing trial order. We'll issue it this afternoon, okay? Multiple pages long, that tells you the rules that are going to apply at trial, including all of the motions that you may not bring. I have a standing order against certain motions in limine, okay? 21 of them. So we're not going to waste our time at trial doing dances on various kinds of motions that already reflect the status of what the law is, okay? Won't be quite as applicable in your case because it's not a car accident case, etc., where they apply mostly, like the golden reptilian theory, the McDonald's coffee cup case theory, insurance, settlement negotiations. We don't need to do the dance on all motions in limine to address all those different kinds of topics. We'll give it to you, okay? But what I do is this. I'm going to require that you guys have, we'll talk about it in a minute, but this is going to cut down on the number of days that we're going to need for trial, okay? First thing is, number one, you're going to have an agreed upon set of exhibits. An agreed upon set. One single set of exhibits for everybody. The court, you, and the jury, and the witnesses. Tabbed and indexed. Okay? All indexed, you're going to agree upon. Okay? They'll be submitted before trial. We can then admit them at the beginning of trial, and you will not have to lay the foundation or the authenticity of those exhibits, okay, in order to use them in your opening statements or to use them with your witnesses. So it will cut down on the time that you need with your witnesses as you're interfacing with the various documents. Does that make sense? Okay, that's number one. Number two, you're going to give me an agreed set of jury instructions, stipulated to and agreed to. Again, this will be in the order. My court clerks have my standard set of jury instructions that you just need to add to and possibly take out one or two that's not applicable to your case. Just include your defenses and your causes of action, okay? And the damages sections for your stipulated set of jury instructions. Make sense? Okay. There will also be included in there what I'm calling a set of stipulated facts that we will read to the jury, okay, to expedite on time. And I'm going to ask that one of you start to prepare, probably the plaintiffs, okay, and then you're going to have to get together with Ms. Kamp and go over the agreed upon set of stipulated facts. We will read those to the jury before you even get necessarily to your opening statements. Okay? That should include the general background of the case and all of the items that are not in dispute. Okay? For example, Ms. Kamp, for your benefit, we don't need to fight over, we do not need to put in front of the jury testimony and evidence on facts that are not disputed. Let me give you an example. A car accident case. People crash in an intersection. Well, we can agree when the car accident occurred. We can agree what time of day it was. We can agree the direction the cars were going. We can agree who was in the car. We can agree what type of cars they were. We can agree that somebody went to the hospital. We can agree that they went to and saw these doctors. We can agree that the medical bills all total this amount of money. Now, whether they're reasonable or not is another story. Whether the issue is whether the light red or green, that's a disputed fact for the jury to decide. That's what we fight over. That's what the testimony is that comes in. But we don't need to take time to put on testimony and evidence about all of these other facts that are not contested. Does that make sense? So in regards to your guys' particular case, you're going to have to go through and identify the issues that are not in dispute. For example, I'm just going off my memory. I don't think it was disputed one time you worked together.
Yes.
Okay, so you could agree when you were hired, you could agree when you were terminated, you could agree what your job role was, you could agree what your job duty and functions were, perhaps. If those are not the issues that are in dispute, the only thing, listen to me, the only thing that jury has to decide is what is in dispute. That's it. And in this case, it may just come down to 2 or 3 particular items. Not a whole myriad of 6 years worth of history and events and circumstances and conversations and so forth that occurred back and forth between everybody. Those aren't in dispute. Okay? We got to go to the bottom line. So, does that make sense of what I'm trying to say? We just don't need to do that. The jury, frankly, they just want to hear what they need to determine. And they don't need to be told 3 times, and they don't need a huge background to be lost in about all of these circumstances. So we're going to essentially, pare it down to just what it is that we need to hear from. Now, experts. I have a pet peeve about experts. Any experts that you're going to call. I want you to call your experts and have them give their opinion up front at the front end of their testimony. So the jury knows immediately what they're there for to tell them. My testimony is this light turned red 5 seconds before the car crash. Right up front. Before you even ask them, what did they study, what did they look at, any of that stuff. Let's give the opinion out right up front. So everybody knows what they're there for. Second, I want you to control your experts. Do not ask them questions where they can drone on for 45 minutes nonstop in an answer to one question. Okay? Keep control of your witness. Yes or no, you control. If they don't, I will interrupt. I will stop them. And I will ask you to do it in the form of questioning your expert instead of narrative of your expert saying whatever they think that they want us to hear and put everything out onto the table that they did for the entirety of the case. Okay? Pare it down. Focus. What does this expert need to tell us? And then you give the foundation as to how we reach that conclusion so the jury can weigh the credibility. Okay? Now, the other thing that would be helpful, I don't know that this very well may be a somewhat large document case. Okay, but generally try to think about the number of exhibits that you really need to present. You know, maybe at the most 20 or 15. I just, what are the absolute relevant ones you want? We don't need, okay, I'm not trying to lecture you, but we don't need 7 volumes of documents, including every single email attachment for 2 years with every single text that went on back and forth, all concluded as a single exhibit. Sure, that's thorough in some ways, but there's no way the jury's going to read through and look at every single one of those texts. Get the exact text that you want, that you need. Get the exact conversation that you need. That's what's relevant. None of the others. Okay? So you don't need to have them in. Now I don't know if there's going to be video or audio. I imagine there is in this case, right? Same thing. Pare down your podcasts or whatever else it is. We don't need to listen to the entire 30 minutes of the podcast. We only need to listen to maybe a few minutes before, leading into it, and a few minutes after. Okay? Focus, focus, focus on exactly what it is that you need them to see to help them decide that disputed issue of fact. It's going to take a lot of work. It's going to take a lot of preparation. And, as I well know, though, it will save you a lot of witness prep time, and it's going to save you a lot of time in the examination of your witnesses. Okay? Now, I know people want to get on the stand and tell their story. That's fine. I don't have any problems with that. But we don't need to hear everything. We only need to hear the relevant things. Does that make sense? When we're doing divorces, I tell them, this really isn't therapy court for you to come in and talk about everything that's gone on in your marriage that was bad or terrible or so on and so forth. No, what we're doing is lighting up their assets. We're determining alimony, we're determining child support. Okay? And so, same thing here in this case. What we're here to determine, that's the evidence that I expect you to put on and defend against. Now that being said, I think we could cut this length of, all of that dialogue was to tell you that I think we can cut this thing down. Okay? To maybe 4 or 5 days, not counting the day of jury selection. We'll have jury selection on a completely different day. Okay, so the day that you come in Monday morning, you start. Okay?
Your Honor, can I ask you a question about witnesses?
Sure.
I just have a question about a witness that I believe knows you well, and so I didn't know how that would, do you need me to?
I don't make the decision. To me, I don't know who the witness is, and I don't want to know.
Mm-hmm.
But you can tell counsel. But the people who are going to decide your case, Ms. Kamp, is that jury.
Right. I just didn't know if you needed to know about her or agreements John has with someone before trial.
What? Who?
Well, do you want me to tell you who it is and ask you the question, or?
With counsel.
I do not know anything about this, Your Honor.
I don't either.
Yeah.
You're going to have to disclose who your witnesses are. The only reason...
I have, but...
Okay, well, if you want to flesh it out now, that's fine. Who is it that you think I know?
Christine Burton. She's President Hinckley's niece.
Don't know her.
Okay. To her, she knows you, so I was just making sure that you were okay with that. And also, after we did a podcast with her, I asked John why we weren't allowed to talk about certain ritual abuse in her Mormon Story podcast, and he said that he had an agreement with an entity of the Church of Jesus Christ of Latter-day Saints. So I just wanted, knowing all of that information, I just didn't know if I needed to present that to you or give that to you.
Your Honor,
So I didn't know what to do there. Because I know that I just wanted to, I guess I just don't know, so I'm asking.
Your Honor, this might inform, if you don't mind, your response on that. Ms. Burton has never been identified in any of the disclosures.
Right.
Can you hear me? Sorry.
Yeah.
She's never been identified in any of the disclosures.
She's in a video that is presented as evidence, and she's on my list that was put into court for subpoenas for the hearing.
Okay. Well, let's handle one thing at a time.
Okay.
First thing is I don't know her.
Okay.
Number two, I don't know that I've ever met her or spoken to her.
Okay.
If she walked in here, I wouldn't know who she was.
Okay.
I don't do anything socially with her. I don't do anything here. I have no idea. Okay. The fact that my father may have worked with President Hinckley and those two know each other and she knows the last name doesn't mean that in any way, shape, or form she knows me or has any involvement with me whatsoever. And frankly, anything relating to the church has no place necessarily in this trial, religion, okay? And no one knows what my religion is. I've never said anything or told anybody. So it has, as far as I'm concerned, at this point in time, it has nothing to do with anything.
Okay.
Personally. Next, what counsel's trying to tell you is what I'm getting back to on your rules.
Okay.
If you didn't disclose your witnesses within a proper time frame, you are barred from calling that person as a witness, and they will not be allowed to testify at trial. Same thing as it relates to the documents. If you didn't disclose documents, and you didn't do it timely, and you didn't do it at the right time, the documents are not going to be allowed in at the time of trial. They will be excluded. And that's what Ms. Tomchak is getting to, okay? So the fact that you're raising this, she's giving you advance warning, you may not be able to call her. She may be shown in the video if they want to see the video, but to call her as a separate, independent, standalone witness on the stand to testify, she may not be able to do for you, okay? Now, that being said, counsel, let's get back to the length of time. Do you think you can do it within 5 days, including giving sufficient time for her to do it?
Plus 1 day for jury selection.
Yeah. Yeah, I think you can.
Wait, so
Succinct.
we,
I'll encourage it.
it may depend on some of the rulings today, Your Honor. I don't know if it makes sense to wait till the end of the hearing to do this, because if there are adverse inferences or certain evidence or witnesses are excluded, it may cut down what we need to have at trial.
Well, that's fine, and you can do that, but I still think we need to set the length of time that we're going to go forward on. I think 5 days and 1 day jury selection is probably good. I think you'll see that things will get distilled down. I really don't expect an expert to be on the stand longer, maybe on direct, longer than 20 minutes to a half hour. And I don't know how many you have, right? And we're not gonna listen to a video for an hour and a half. You're gonna cut it down to 10 minutes, 5 minutes, right? So that's gonna narrow things down quite a bit. Now, with respect to the one last thing on the jury trial, okay, I'm gonna want you guys to consider having the jury in from about 8:30, 8:45 to 2:30 in the afternoon and letting them go, and only have a half hour short lunch in the middle of the day. And I think we're gonna see if you guys would be willing to have the expense to bring the jury in meals so they can eat and be done in a half hour and not go out. Otherwise, it's gonna take a little bit longer. But give that some consideration. I'm thinking about not having a full, long day. That allows them to get to their other work, do other things that they need to do in their lives. It allows you guys to prepare for trial instead of working till 10:30 at night. It allows me to get to my other cases, my other matters that I have to do that are still ongoing during the time of trial. Okay? So that then being said, I am not too uptight about how soon we have this. I'm willing to give you a little bit of time to try to get you guys set up and prepared. As I said, we'll send you out a ruling, standing order on your jury trial. Okay? Normally, I give jury trials with 3 months or less. That's probably a little quick here, and I'm willing to look a little farther out for you. I can, now I'm not saying take these dates, I'm just saying this is when I start to open up. The end of May. I've got a week at the end of May. I've got first week of June, and then it's going to be July. I could do July the 8th, and I could do July the 22nd through the 25th. If that is helpful. I cannot do the first part of August area of the 4-day jury trial set then. Can those dates work for you, like the 22nd through the 26th of July? You're out of town, family vacation?
Yeah, July.
Personally, I would like the June dates.
I'll be at a wedding in Alaska in June. The dates you gave in June, I'll be at a wedding in Alaska.
Doing what in Alaska?
A wedding.
A wedding. Now, if it was fishing, we would just, a wedding is something different. Okay, when do you come back?
July 2nd?
You come back on July the 2nd?
Yes.
Could you go June, that's quick, June the 3rd through the 7th?
No, I'm sorry. At the week before that, I'm going to be in DC for the week. I'm getting sworn into the United States Supreme Court. And I'm taking my son with me. We've already bought tickets.
I've done that as well. So, all right, so did you say the 15th of July through the 19th? Anybody?
I'm sorry, Your Honor. I am in Idaho the whole week. That week, it's a planned camping vacation for my son. I know that this is
Okay, the 20th.
this is when we plan all of our family vacation time. My apologies.
22nd through the 26th.
I'm here then, but it would be incredibly difficult to prepare for trial when I'm going to be gone the entire preceding week and the week before that. That you said August, and August works much better for me, Your Honor.
I said August, I'm tied up. I've got a jury selection August 1st and the whole week jury trial the 5th through the 9th.
Late August and September, or?
I generally don't go that far out if you're ready to go. Can you do the 19th through the 22nd?
Oh.
August?
That works for me.
Ms. Kamp?
I'm checking.
That's only 4 days. Did you mean through the 23rd?
Yeah. I did.
That's fine with me. I'd rather it be much early and have asked for it to be much earlier.
Yeah, I would too. Okay. Take a look for the 15th of August. That's a Thursday. We're going to see if they have any jury selection dates available.
What was that?
Okay, what times do we have on the 15th? I'm sorry? All right, let's take a 9 o'clock. Hold on one second, counsel. I'll catch up with you. Okay, we're going to do jury selection on August the 15th. Okay, August the 15th, 9 o'clock. You have to be here in court with me to do the virtual jury selection. We will send to you the jury questionnaires in advance as soon as we get them. Go through your questionnaires, decide if there's any follow-up questions on the responses that they've given, and we'll pull them in potentially and talk to each one of them. I conduct the vote dire, not you. Okay? Meaning I ask the questions of the jurors. I will let you and counsel ask some questions after we have them in individually, but not to the entire panel. Okay? So, jury selection will be on Thursday. Trial will start Monday morning, the 9th through the 23rd. Okay? That be okay for everyone?
Yes, Your Honor.
Now, you're going to get the deadlines already in the order, so we don't need to take any time going over that, including when you have to have your exhibits and all the other things sent to me by. Okay? Yes, number of jurors. I'm sorry, I'm ignorant on social media things. I don't even really get on them. I just don't know how well known or how available or how widespread your podcasts are. But that would have an influence potentially on the number of jurors that we may need to call in. So I'm ignorant. Tell me what you think we may need. 50 jurors to go through? What do you think? I mean, how many views Can somebody put in context what she does?
I
Is she
can.
widespread across the country? Is it here locally? Is it 100,000? Is it 50,000? Is it 2 million? I have no idea.
It's less than 1,000, and views right now are basically nothing. I have a podcast on it for over a year.
Okay.
So mine is minimal, nothing.
Okay.
John's is in the,
Well,
or at least you guys can answer. They gave me statistics a little bit ago.
the reason I ask is my other court clerk was familiar with the podcasts when we were assigned this case. So she asked me, she says, like, I kind of know. I said, then just stay out.
I know that, at least based on the information provided to us, there have been at least 20,000 views of some of her podcasts, but we don't know. I mean, the 1,000 might be the correct number now, but at some point she had a much bigger audience.
And John's
Okay.
is about,
Okay, I would
what do you
say,
guys want to say what yours is?
I'd say let's call 50 jurors. Okay? And then, I'm just going to tell you up front, the fact that they may be aware of our podcast or may have seen it, I don't necessarily think will be a basis for me to exclude them for cause. They're going to have to express something more than knowledge or awareness of her podcast. They're going to have to express some sort of knowledge about the case or the individuals involved in the case, something of that nature. Okay? Is that fair for what we're thinking? So what I'm trying to say is, you know, everybody in the world knows Donald Trump. The fact you know Donald Trump isn't going to get you kicked off the jury. Same thing here. The fact that they're aware of this podcast isn't going to automatically get them thrown off.
Does it matter, Your Honor, if they know John and his podcasts in jury selection?
Whether they know him, yes, potentially.
So
But
do you-
his podcast isn't what's on trial. Yours is.
Right.
His-
But
The way I see it.
evidence from his podcast is used from them in
His-
trial on his podcast that they have submitted.
I don't know, I've seen it at council. Are you planning on using his podcast for evidence?
Excerpts of his podcasts, yes.
Okay, so knowledge of his podcasts may be relevant, so we'll have to ask the jury about that. Okay? All right. Okay, so anything else before we move off trial settings and some of the information here? Yeah, Ms.
No.
Kamp? Consider if you can or really do want to get somebody to try to help you through this process.
Your Honor, I would love that with everything in me, but they have already drained me of $300,000 to this point. And so I unfortunately cannot afford counsel. Believe me, I would love for someone to be sitting here next to me.
Procedurally, some of the things we'll talk about, and I can assist both counsel and you in that manner only, because they also need to know how the courtroom is run. And so that's when you'll learn and get educated about how we do things here. But you're going to have to learn about preemptory challenges. You're going to have to learn, you know, all these other kinds of things to try to help yourself. Okay, let's see. Counsel, do you have anything, Ms. Kamp, anything else on trial? Let's move to the motions and we go from here. Okay. Anybody have anything else?
On trial? No.
We good till 11?
Yeah.
Okay.
You're right.
Okay. You sign it for me.
Well,
Yeah. You were authorized to sign that order, canceling the hearing. Okay. motions. Now, Ms. Kamp, I want to give you the benefit of the doubt as much as I can, to the extent that I can. Okay. However, I believe most, if not all, of your motions that have been noticed out and brought to the court's attention have been handled, dealt with, and ruled upon. It is not my practice to let any motions or anything slip through the cracks and not get handled and dealt with. Okay? Now, you have submitted this recently, this huge page, I don't know, pages numbered, on the 17th, 4 or 5 pages of different motions to reconsider, objections, motion status conference hearing, motion to file counterclaim, motions to add parties, motions to do this, that, and the other, right? I had my clerk identify by the docket number the ones that you said you thought were an issue. I would like to take a couple of minutes and give you the opportunity to tell me and identify any motions that you believe we have not ruled upon or heard from you. Okay? And I'm not talking about going back and revisiting the motions that we ruled upon, such as your counterclaim or adding other parties. Okay? Those were handled and those were dealt with. And then I'm going to ask Ms. Tomchak, because she's more on top of the pleadings than I am at this stage, to help me understand whether or not any motion that you are saying we've not heard from you on has or has not, and then we'll hear from you on it to give you that opportunity. So after today, there isn't anything else that you can raise, discuss, point to, or say, Judge, this is sitting in your queue, you haven't acted on it, or you're ignoring me, or you're not paying attention to me, okay?
Mm-hmm.
So when we leave this courtroom today, everything will be up to date. So can you tell me what motion or so forth that you think we have not heard that we need to make a ruling on, either for or against, that we haven't? Because I'm happy to do it.
Yeah, so I guess back in December through February, I asked for a hearing with you, and I did actually do a request to submit for that was never answered.
Okay.
But
did a ruling come out on that request for a hearing on that motion? In other words, as I told you earlier today, not every motion of yours is entitled to have a hearing,
Right.
but it is entitled to have a ruling.
Okay.
So did
I
you
guess-
do a ruling on that? Do you want to tell us which one?
Yes, I guess, can I speak plainly for just a moment?
Yes.
Okay.
Please.
The issue that I'm having in feeling like I'm being heard is, or that my motions are being read or heard, is that I have asked for, since the beginning of this trial, for raw video footage of the videos that are being used in this case. Raw video, not the ones that John has edited since they've been posted. Like the raw version of them, not uploaded to some site where I can't download from, but the actual raw videos of all the listed videos. Okay. And then just 3 things.
Okay,
just 3 things.
I understand. Question: why is it important from an uneducated standpoint to have the raw video?
Yes.
Can't raw video be adulterated and changed if you were given the raw video?
The raw video will show if he has changed it.
But can you change raw video if it was given to you?
Can I change it?
Yeah, can anybody? I was given the raw video, can I go in and manipulate the raw video?
You can change any video that's been given to you, but I need to have an expert look at the videos, because my argument is, from the time that the video was shown, this video that they're using in evidence, he has since edited the video, which he...
Okay, that's number one.
Yeah.
Okay,
The second is almost 90% of what I said on this video that is so-called defamatory can be proven with the surveillance camera footage that is in Mormon Stories studio. That surveillance camera footage is, or at least when I worked there, was like gold to John. If we didn't have room on our hard drive, he would delete a podcast rather than deleting the surveillance camera footage. So for him to claim that, oh, he just doesn't have it anymore.
You're getting too detailed. You
Okay.
just need to tell me
I need the surveillance camera footage from the 8 months that I worked at Mormon Story Studio.
For the whole 8 months? Why is that relevant? Why is 8 months?
Because the sexual harassment will be on the video. Because the mental abuse will be on the video. Because the meeting I had with John, both of them will be on the video.
Okay, next question. Don't you have dates of when these incidences and events occurred? You could say specifically, I want the video for July the 25th, 2019, one for August 1, 2019.
I can do that.
More specifics, because it could be overly duly burdensome to try to produce 8 months of daily video.
So I could,
That's number one.
yes, I can.
I don't know that the video, is kept or stored longer than a certain length of time. Sometimes it's kept 24 hours, sometimes it's kept 30 days. I don't know. Okay, but that's, I'm just throwing that out there. Right, so the raw video, surveillance camera, what was the third?
The third is communication. They have asked for more than 100 people, full conversations. I can't even just pick out the little pieces like you're asking, the little pieces of the conversation that have to do with this case. They asked for full conversation. So I'm downloading years of conversation of some of these people and giving it to them. Years. And over 100 people he's asked for from me so far. I have gotten zero communication between him and some of the people that I've asked for. And if he gives me any communication, it's like one screenshot or like a couple things. And I know he's talked to these people. He's told people, he's talked to these people. He mentioned in his deposition he's talked to these people, and still they have not given me this communication. So I would like all communication that's about me or about this case to be given to me. I have done the same for them. Even videos that no one has ever seen and it's never been downloaded or uploaded, I have done for them.
Okay. So those are the only 3 things that you're saying that you don't think that you've been heard on or need to have a ruling on from me. Is that right?
One more.
Okay.
Subpoenas.
Okay, I've made rulings on the subpoenas.
Correct, but I think that I would like to tell you why I think that it was, maybe you can look at it again.
There's a motion to reconsider.
Yes, because the subpoenas, John is being the expert of the finances in this case. He is the expert. He has placed himself as the expert in this case. The only way for me to have information to go over to see if his numbers are actual numbers, because I already have had incidences of him creating things, and I can show that in this case. So I need to have subpoenas to the financial institutions to show the donors that he is saying are, stopped their donations. I need to have documentation from those financial institutions to see if his numbers match up with what their numbers would say. It's a huge part of this case. It is huge. And for me to not be able to have any of my subpoenas, even after you ruled that I could, and then they were squashed again, and they're not their subpoenas, they're third-party subpoenas, which they should not be able to object to anyways, according to the rule. I read the rule multiple times. That's what it seems like to me.
Okay, that's fine. Let's go back and handle a couple of questions that I have concerning this. Okay, and I will let Ms. Ponchak respond. Number one, for the video, the surveillance cameras, and the conversations, did your attorneys or did you request this information during the proper time period when discovery was still open and was it requested?
Yes.
Okay, that's number one. Number two, if and when it wasn't provided, did you bring a motion to compel asking me to order them to produce the information or the discovery that you had asked me?
Yes. I don't know. Yes, I did. I have a motion to compel. And I believe I'm hoping I used the right wording.
Okay. Because see what happens, this is the same process that they did on you. When you didn't provide them the information that they asked for, right, and wanted to hold you in sanctions for it,
Yeah.
they brought a motion here for me to make a ruling on it, to call the balls and the strikes, so to speak. Yes, you need to produce it. No, you don't. No, it's overdrawn, narrow it down, etc. I don't recall you ever, or your counsel, within the time frames, now I could be wrong, can you correct me, to deal with your raw video, the surveillance camera, or the conversation. But that being said, okay, that would appear to be, in some ways, extremely wrong and would need to be more narrowed down, so it isn't so burdensome.
And that's fine. I can do that now if you want me to.
I don't know that you can. You may be too late. The
Okay.
time to do that may have already passed. And if you haven't brought a motion to do that, that's fine. Now, you are correct in regards to the subpoenas. You can issue subpoenas to anybody you want, okay? And the basis for the third parties to object to, okay, they can raise an objection to it. Zion's Bank or Continental Bank, whatever. However, the owners of the account, who the information that you're trying to get from, they also have a basis to object to or try to limit the scope of the financial information that you have or that you're requesting. You're not entitled to get in and look at every financial information and penny that he's ever earned, where it came from, and those kinds of things. You're not entitled to that.
Yeah, and I don't want to be.
Okay, I'm just saying you're not entitled to it. So I don't know if we dealt with this subpoenas on his finances or not. I don't remember, but we can go back and deal with it. Ms. Tomczyk, do you want to address the three concerning the raw video, the surveillance videos, and these conversations with individuals?
Yes, Your Honor.
Have we ruled on them?
Yes, Your Honor. And I think it might be helpful if we could share our screen with you so we can show you exactly where you've ruled upon them. Is there a way for us to do that?
Yep.
Sure. So the motion to compel discovery was denied on February 2nd, 2024. It's docket number 510. The reason that the court denied the motion to compel discovery was because it was untimely. It was served on the 15th of January, 2024. Can you bring up the slides where it shows where she made the request? It was the January 15th. Okay, so can you see this, Your Honor? Hold on one second.
I see a beautiful mountainside with some clouds. You should.
Oh, there we go. There we go. So you can see here, this shows the date of her request. It shows her request for the raw video footage and the surveillance. It was dated January 15th, 2024, which is the last day of discovery. So the court denied the motion to compel, saying it was untimely because she waited until the last day of discovery to serve it. And under Utah law, you have to serve it. She should have served it at the latest by December 18th. That was the day she had to serve it in order for it to be timely. The court also denied it on the grounds that she had exhausted her discovery. She had already served 11 requests for admission. Sorry, she had already served all of her requests for admissions, all of her requests for productions, and all but one of her interrogatory requests. The court also denied it on the third basis that it was issued for an improper purpose. The court decided that the information requested in these requests were harassing and duplicative. And then on the last reason the court denied it was that the motion was improper and premature. So the court did deny the motion to compel discovery. But I do want to specifically address, so even though the court's already said you're not entitled to these things because you waited until the end of the discovery to get them, I do want to address specifically the surveillance footage, because I think that that this really shows just how that this is a fight over nothing, and it's something that we've told her. We wish we had the surveillance footage because we are certain that it would confirm our version of the case. We have been consistent throughout our pleadings, throughout our arguments. Our version of this case has never changed. And the problem is that the surveillance footage expires after 7 days. You can see here, this is in front of the court is the Cove policy that talks about when the surveillance footage is erased. It's after 7 days. And remember here that the meeting was on August 20th, where this all started was on August 20th. The board meeting where they discussed the meeting where they had this interaction was on August 25th. Ms. Kamp was not terminated until, was it September 1st? September 2nd. So there was not even a hint of the fact that there would be a dispute, or that litigation wasn't threatened until, I believe, the middle of September 15th, if I remember correctly. So by the time Ms. Kamp, by the time that there was any sort of, hey, we need to look at these dates, the surveillance footage was long gone. We wish we had it because it would be very helpful to us.
Did you communicate that to Ms. Kamp?
Yes.
So she understood that this information was...
Yes, we've told her we don't have the surveillance
Did
footage.
you told her that in writing, or did you tell that orally to her? Did you explain why it wasn't available, that it was erased after 7 days?
We have tried. She does not like to communicate with us, but it's not in writing. I believe it was in our opposition to the motion to compel, but I don't remember specifically, but we have told her that we don't have it. And I do want to point out, because I think this is important, Your Honor, her claim that this surveillance footage was really important and saved is completely inconsistent with what she said previously. And we have a clip where she talks about the surveillance footage. This was at the August 25th board meeting that I think will be helpful for the court to see that she knows very well that the surveillance footage is not something that Mr. Dehlin keeps for months and months. Do you have that clip ready? It's just a few minutes, if that. This is where the board is asking about what happened during the August 20th meeting. And Ms. Kamp had claimed that she had recorded that meeting, but then said that she had deleted it.
I offered it to them, and they said they didn't want it, and then I deleted it.
Is it working? It's.
Okay, so thanks for telling Carrie. So she's actually up to speed, and she kind of.
Can you hear it, Your Honor?
Didn't know if.
And I can tell it's obviously an emotional art for you, so thanks for sharing.
Sorry, Your Honor. Technology.
Can I ask a few questions? Would you consider this normal behavior?
Okay, it doesn't look like we have it teed up, but I will just say what it says, and then if we can find it, she's the one who suggests, hey, maybe we should look at their surveillance footage. It was something that they were arguing over what happened at this meeting, and it wasn't John who said, oh, I have months and months of surveillance footage. It was her saying, well, maybe you should check the cameras to see if they picked it up. So her saying that he had months and months of it is just not true. We wish we had it because we think it would be very helpful to our case. But ultimately, she asked for this stuff after discovery was over. She asked for it after the dates had ran, and she asked for it after she had exhausted all of her discovery requests. And that's why it should be denied. If we had the surveillance footage, though, we would offer it because we think it would be very helpful to our case. With respect to the subpoenas, the court denied the motion for the subpoenas on the same day, on February 20th, 2024, in docket 511. And the court denied those subpoenas for a number of reasons. It denied them because they were issued without proper notice and 9 days after the close of fact discovery. They were duplicative of previously quashed motions. And I know November 16th was a long time ago, but during that hearing, the court very specifically told Ms. Kamp that if she wanted to reissue subpoenas, she needed to follow very specific procedures. She didn't do that when she issued these subpoenas. They were virtually identical to the initial subpoenas that the court quashed because they were improper. There wasn't any excuse for this delay because the court had told her on November 16th that she could reissue the subpoenas then, and yet she waited until 9 days after the close of discovery. I believe the court also denied it on the basis that some of the information requested constituted trade secrets that she didn't have appropriate access to. So the court has fully addressed each of the issues that she's raised. It's done it in its orders, and it's been brought before the judge. I would like to mention that these very same issues are in a motion to compel that she recently filed. So if the court rules on this today, we would like to be excused from having to respond to that motion.
Can I respond?
Yeah, please. So, is Ms. Kamp wrong?
Ms. Tomczyk?
Ms. Kamp, is Ms. Tomczyk wrong that I
Yes.
ruled on them?
No, you
I did rule.
you ruled on some of them that included them, yes.
Okay, so what did I not rule on?
Can I explain
No.
the things that she said that were wrong?
I'm trying to make sure that we hear any issues that you had that were not ruled on. That's the focus.
I guess my point is that you ruled on information from her that was wrong, like that she either manipulated the court with evidence, like only giving parts of the evidence, or lied basically to you, and then you ruled upon her proposed order with the lies within it. And so it's hard to see motions being signed when there's lies within the motion that I've given evidence against. So it's frustrating to me because if I can start with...
It's a pretty strong accusation saying that she lied to the court.
I know, but she did. So I don't know how else to show you.
Did you prove it?
We can bring up the motions, like her proposed motions, and I can tell you what within them is not correct. But if I could just have a moment, because I don't know all the fancy words. I don't know how to present it in this way. But the thing is that so basically in December, I ran out of money to have someone represent me here. I emailed the court, your court, and asked for an extension so that I would have time in learning all these years that she's had, and trying to get to know all the motions and how to reply to them the right way and all the things. I just needed time. I also had, the holidays. I also had 2 daughters' weddings within that month. And one of them being out of the country for a couple weeks. No extensions were responded to by the court or them. The appellate court did. They responded right away, and they gave me an extension to be able to respond to that. So not only am I trying to go through evidence that was never given to me by Hepworth Legal, and going through all of that evidence thousands and thousands of things, which I'm still not even all the way through, to be honest. Thousands of evidence, 2 daughters' weddings, the holiday, an appellate court appeal, the end of discovery coming in less than a month. You know, and trying to reply to all their motions before that happens, trying to learn all of these things. I'm not asking for, you to, give me the world. All I'm asking was for an extension to learn the things, to go through the evidence that I had, and to respond properly. And I tried to ask for that, and was not given that by this court. And to be honest, I wasn't. And so I asked for hearings. You know, I did multiple times because I didn't know how to do it properly, and I was overwhelmed with everything asked of me. Also working 40 hours a week and being a mom and a wife, you know, and trying to be there for my daughters during their weddings. It's not that I was trying. I don't care what they want. I will give them everything. Have my bank accounts, subpoena my bank, go through to the transactions. I don't care, because what I said is the truth, and I will never say different. I am the victim of him. I am. I'm not asking for the world. I'm not. I'm asking for me not to be superhuman.
So we made a ruling on it already.
But you didn't hear me, and I didn't know how to convey to you, because I didn't have a proper amount of time to get and give you what you needed. I'm not asking. I just needed time, and I wasn't given it. I wasn't. And you didn't hear me, and I did do everything to submit. I did.
Thank you. Counsel, anything else on these?
Is there anything specific that you have questions about? I mean, I think
No, I mean, it seems to me, from what I'm hearing, she's simply asking again and revisiting the same motions that we've already ruled upon. And she doesn't get a sense of fairness because she doesn't have the same, she feels inadequate to deal with being an attorney in her own case, and not knowing the rules and complying with the rules and the deadlines and like what we're required to do, hold her to the rules when she's pro se. She's saying that's unfair.
yeah.
And there isn't really much I can do about that, except for I will know, Ms. Kamp, I tried to give you the opportunities back in November when we were dealing and working on these discovery issues back then. Keep the door open. Ms. Tomchuk was quite upset with me that I did not go her way in allowing and shutting off and closing down these things of discovery, but rather giving you and your counsel at that time more opportunities. And then for some reason your counsel is left. And so you find yourself in your predicament that you're at. And we have to live with what we have. So that being said, do you have any other motions or topics that you think we have not ruled on? If so, I'd like to hear about them. If not, we're going to move on to the other motions that we have set up for today.
I guess I just don't know how to do this. I don't know. I put the motions in. I don't know how to do this. I don't know how to. I don't think it's fair. I don't think it's fair you're ruling against all the motions I do put in. So, to get evidence that I need and giving them, approving their motions, their proposed motions that are sent in. And so I don't know how to defend myself when I can't get any evidence from them.
I can't.
And you keep. Can I just address the subpoenas then that she's saying? Because she did just say something that was incorrect. So in November, you quashed the subpoenas, you said that we could reissue the subpoenas,
There you go.
which I did.
But you didn't follow the.
But I did. I placed them into court. They were told that the subpoenas were in court. Your people downstairs put them into court for me. They uploaded them. I went to the window, and they sat there for a week. No one said anything, and so I sent them off. What did I do wrong? Why were they quashed again? Because then I'm having the people I subpoenaed call me, telling me Jenn has called them and told them not to send me documents, to object to not produce, even though they were ready to produce. I had 2 of them call me saying, I was told that she might be objecting to the subpoenas, so can I have an extension? Can I not? I'm going to wait until I hear from the court to see what, if her thing is approved to quash them. And it's not, I followed the rules. I placed them into court. I waited a week before I sent them, and then I sent them, and the people were ready to send them to me. And then they get phone calls from John Dehlin's representatives, OSF's representatives, telling them not to produce them. So,
Counsel?
Yes, Your Honor. I think she's confusing 2 different things. When I said that the subpoenas were improperly issued, they were improperly issued because they were issued after the close of discovery, and also because the court had specifically said, with respect to, I think it was Donor Box, Wells Fargo, and there was one other subpoena I don't remember off the top of my head right now, said that if you reissue these subpoenas, ABP. If you reissue these subpoenas, you have to do it following these specific, it has to be attorney's eyes only. There has to be no personal identifying information, and said that there needed to be specific things in those subpoenas. So when I said that they were improperly issued, that was what I was talking about. She did not follow what the court ordered with respect to those subpoenas. With respect to the people not responding to the subpoenas, I never told them not to respond to the subpoenas. I merely offered them, I said, this is the motion that we've filed. So then they can look at the motion that we sent objecting to the subpoenas and decide whether they wanted to respond to them or not. And it sounds like most of them decided to ask for an extension to see how the court ruled on those subpoenas. When the court quashed the subpoenas, they didn't provide the evidence. I do believe that there was one subpoena that did get responded to.
yes. Which she asked for the documents and I gave her. But they're third-party subpoenas. She shouldn't have contacted them. They were ready to be produced. And I followed according to what I read in your ruling with the subpoenas. And I don't see the area that she's talking about. But if I did...
What do you mean you don't see the area she's talking about?
Where they needed to send them to me already redacted. My understanding was they would send them in and then they would be redacted. So I might have been misunderstanding what the court said, but that was my understanding. But if I'm wrong, I'm happy to reissue the subpoenas in the way that Your Honor tells me to at this moment. And I would like her not to contact them, and I would like my subpoenas to be able to be sent without being.
I believe the court's initial ruling that they shouldn't have been issued after the close of discovery.
There's third-party subpoenas, and he's already told us today that third-party subpoenas are not within discovery. They can be sent outside discovery.
No. Third-party subpoenas to gather factual information as part of discovery have to be issued within the deadlines.
Okay, I must be misunderstanding two cases that I sent in that judges ruled against that. So I don't know.
I don't know
what to say. Okay.
I know, and that's the struggles that you're having representing yourself.
Well, I know, but I found two cases where they ruled against that the third-party subpoenas could be sent only within discovery. They can be sent outside of discovery as long as it's a third party.
If it helps, Your Honor, I did explain to Ms. Kamp during our meeting, conferred that trial subpoenas can be sent outside of discovery, but not fact discovery subpoenas.
That's right.
Okay, so if I sent a trial subpoena, could Ms. Tomczyk object to that?
I can't give you.
Okay, I'm going to take that as I can do that, because that's what was just said.
Now, I want to make it very clear, trial subpoenas are saying come to trial, not bring documents.
They're saying come to trial and bring documents.
No, that's incorrect.
You can ask them to bring documents.
No, that's incorrect.
Okay. Well, you do what you think you need
Okay.
to do. And we will deal with it from there. Okay. So that takes us to the most recent motions that were in, because that takes care of everything that Ms. Kamp has, as I recall, right?
I think there's 3 on this paper that you gave me
I don't,
that goes along with court.
well, we had some,
It was number 3.
let me just pull up my thing I mailed out. Okay. Where's our notes? Here it is. Just a sec. Nick, help me on that one. 608. 608. Yeah, thank you. Under the notice of hearing. Nope, that's.
I guess that one maybe you've already decided upon or are still thinking about.
Notice of hearing on motions under 607. Okay, yeah, those are the ones reviewed today. Okay?
So
Ms. Tomczyk has brought 3
Yeah.
motions that are pending that I have to decide.
right, and so below it are mine that you're,
Well, that's what we've been covering. Okay, so
so you did 1 and 2 to your,
I'm sorry, I went through all of your motions that I could see before I
Right.
made this ruling to see that it looked like that it had been ruled upon and decided. And everything that I came across was. So that's why I asked you today. I thought as a general catch-all, I need you to tell me if there's something that we missed.
okay.
Is there anything that we've missed? If not, we can move on to Ms. Tomczyk's motions.
I can go through the ones that I think you missed. And I don't know if there's like a,
Just tell me, and Ms.
Okay.
Tomczyk and I will see if we've already ruled on them, or if by chance something has slipped through the cracks.
I just think you would have ruled on them differently if you would have allowed me to speak.
That's something different.
Okay, but one of them,
You're mixing apples and oranges.
I know, but they affect me the same way in this court case, so.
Okay, is there anything that I haven't ruled on?
Yes, the request from hearing that was on the 5th of December, and then the 2nd of February, and then the 12th of February, and then the 27th of February, and then the 3rd of 6th, or the March 6th, and then April 5th, where I asked you to please be heard and speak to you, and I did request to submit within those 7 requests. It was never ruled upon, any of those, but the motions within it, I guess some of them weren't ruled upon maybe, but some were. motion to file the counterclaim and add additional parties, which I still wish I could speak on today because
It's already been ruled on.
I know. It's okay, we'll do it in a different court.
Okay.
To compel discovery and impose sanctions. I don't believe
Okay, I've ruled on those, did I not?
I know, but you ruled on them without giving me anything. Like, I don't know why you ruled that way. Like, I don't know why you ruled that I get no evidence and he gets everything from me.
Okay. I think if you read the rulings, it will explain to you why the rulings were made.
You sign her proposed rules almost every time.
Yes, that's the way that it's done.
I know, but you don't.
Both counts. Okay, if you need to understand something, and maybe we can get this clearer, and we can get in there. The court does not necessarily draft every single order that it's.
I don't expect you to.
Well, you just implied that you did.
No, I'm just.
Because I signed her order that she proposed.
Right.
Normally what the court does is it asks the winning counsel to prepare the order. Okay? That's standard in every case. If the party prevails on a motion, the court will direct counsel to prepare the order for its signature so the court doesn't have to do it.
Right, which is fine.
So,
I just know that you're
just implying that there was some sort of
No.
bias or prejudice because I'm signing her orders that she submits to you. And I'm trying to tell you that's not the case. Okay?
You told us in the November 20th hearing that you did not read my motion before you signed her proposed motion.
On the one back before, but we got that straightened out in that hearing.
I'm just saying the next time it was submitted, you said the same thing. Like
The order was submitted, it's the same thing, but we straightened it out and got the information, the evidence in that hearing. Okay. What else is missing? The fact that I've signed her orders explains the reasons why I've made the rulings. What I'm getting, Ms. Kamp, is you are not accepting, it seems, the rulings and the decisions of the court. So you attempt to revisit them and ask them to be looked at again, or to give you a second or a third or multiple opportunities to present the same things again. And you can't.
Well, that's what I'm wanting to speak about. If I can speak about them with something that's already ruled upon, because you didn't read it. You said you would. If we filed it again, we filed it again. You said you did read it, and you filed against it because it was close to the end of discovery, which I understand, but then discovery was extended. And the plaintiffs did not give me discovery. They did not produce because they were withholding discovery until the 19th of December. The 19th of December. That is after those two motions were put in. So having the new discovery, this new evidence that I didn't get until the 19th of December of 2023, within 20 days, I had rewrote a counterclaim, including the evidence that is damning to them, and included that in the counterclaim, adding the additional persons, and then resubmitted it. It's not because I'm just resubmitting things over and over and over again because they're the same thing and I just don't like your ruling. That's not true. That's not true. I'm submitting them because they're withholding evidence until the 19th of December. So from the 19th of December forward, that's all I had. And from the 19th of December forward to the end of discovery is 24 days. So in 24 days, I have appellate court appeal. I have $2 weddings. I have all those things I listed previously. Do you see, like, it's not just what they're saying. It's not just I'm, just hate you, Judge Faust, and I just think you're just wrong. It's just that, like, I'm trying, I got the evidence the 19th of December. They withheld it knowingly. Till then. And I have weeks to do everything I just listed. That's unhuman.
Thank you. Counsel, you disclosed within timeframes, correct?
On the date the court ordered us to, based on when they served their discovery, yes.
And you didn't delay in providing it?
We did not.
They did delay in providing it because they had it beforehand. They were holding on to a privileged waiver or something that was named that, something to do with privileged something. They were willingly withholding it, even though they should have not done that.
If they produced it by the time of the deadlines that they were there was nothing.
I know.
wrong with what they did.
But I also requested an extension that you never answered. And I submitted an extension that you never answered.
Okay, and let's talk about the request for extensions and so forth. We talked to you about the rules that you have to follow in making motions to submit.
I know,
Okay.
I'm sorry. I just,
You have to follow the rules.
I know. But you're asking me to be
Submit.
superhuman.
No, I'm not.
You are. In 20 days, you're asking me to do things that one person is not able to do.
Okay. I find then that there is many outstanding pending motions from.
There is.
Okay, Ms. Kamp, tell me what it is.
There is.
Point it out to me. Let's
Okay.
deal with it right now.
Let's do it. Okay.
What is it?
Request for extension for expert witnesses. It's number 4 on the paper that your court provided to me.
Okay,
Docket 570.
and I think. Okay, there was an opposition that was filed to that, right, Ms. Kemp, by you. 572 or 322. And then, or 573. And let's see. Was that notice up with a request to submit? You may have made a motion, but do you have a request to submit to me to rule on it?
I didn't because it was.
There is the problem. Remember what we talked about earlier? To
Right.
avoid the problems, the rules say that they're not given to the judge or submitted until a request to submit has been given. And they can sit there for years. Okay? That's why I took the effort to explain to you in my request for rulings for you to understand what must be done in order for your matters to come to my attention for me to rule on it.
Yeah.
Okay?
Yeah, and I didn't because I knew we had this
Okay.
hearing, so I just was bringing it here.
So there's no request to submit on that extension, and there still isn't. I can't make a ruling on it. I can't make rulings on motions that are simply filed with the court. I can't be premature and simply deal with them, okay? Because somebody wants me to handle them. I
Because
have to have the procedures followed. Okay, so that was one, your request thing. I haven't responded to it, but there's no request to submit, so I don't need to respond to it. I can't respond to it, because no request to submit under Rule 7G is given. You've got the notice.
can I
of what
orally
you have
request
do.
to submit?
You file your request to submit in writing.
Your Honor, we're prepared to argue that motion if you like, or we can wait till she submits a request.
So you're willing to waive that?
Sure.
Okay, let's come back to that then for a minute. Okay, let's identify any others that she said, so we're done with this. So Ms. Kemp, that's number 1. Right, that was extension of time for experts, right?
Mm-hmm.
Okay. Any other motions? Let's bring this to a conclusion.
Yeah,
What other motion?
there's a motion.
So for the record, the reason the motion for the extension of time for expert witnesses was not ever heard or addressed by the court or noticed at the hearing is because there was a failure on the part of Ms. Kamp to submit and file a request to submit under Rule 7.
Okay,
Okay.
but I did. Sorry, I just found it.
Okay, you did?
Yep, I did. It was the paper that you were holding at the beginning of this
Oh, yeah, the one you just put in a few
Yes.
days ago?
Yes.
This does not comply with Rule 7.
why? I put all the dockets and the dates. I did a request to submit. There's multiple ones within it. I don't know if that was wrong.
You do, you do them separately. Okay, this is wrong. Okay, but nevertheless, we're going to address it today.
Yeah.
What was the other one? I can't. Here it is. Here it is. Okay.
The other one was a motion and fourth request for hearing on rulings and motions dated April 5th, 2024.
I'm sorry, I was looking at your list trying to find it. Tell me what it is again.
Extension for expert witnesses.
That's the one we just talked about.
Oh, so you want, the next one is motion and fourth request for hearing, but within that motion, the things that I wanted to talk about was the things that were missing from discovery that I believe that I have asked repeatedly for within discovery
So there
and
was
compel.
there was no motion to compel filed.
There was.
Where's the
But
motion
you-
to compel that was filed?
Your Honor, this is the one that was denied on February 20th, 2024, docket 510.
That we've already just talked about.
Yes, Your Honor.
Okay, so that's been handled. Where's the next one? Do you have any others?
I think you're going to deny all of them
No.
because they all have.
I'm just trying to make sure that there isn't a motion out there that I have not.
Well, if this is a motion, it is a motion, but it says the other motions within it. So if you're not going to revisit the motions, then that motion is basically nothing.
Well, if there was subparts of it, counsel, do you know if there was a subpart of a motion that wasn't addressed in the ruling?
They wouldn't tell
I'm
you
not
what there
aware
was.
I'm not sure what she's talking about, Your Honor. I'm
I think
sorry.
she was talking about a motion to compel of some sort of information.
So there was recently, Your Honor, like I think last Tuesday or Wednesday, she filed a motion for sanctions. That's the one that you had us argue at the beginning related to surveillance footage. That was the one where we said you have to have a motion to compel first. The motion to compel was denied because the requests were untimely. I don't know if that's what she meant, but we have argued that already.
Yeah. And Ms. Kamp, the reason, again, in part, that I gave you the information in the notice of how to notice up your hearings and to limit them to one motion at a time is to avoid this confusion and intertangling of what it is that is sought to be asked for from the court on what issues and motion. You can't just throw it all into a big basket and say it's there. We're trying to untangle that today. That's what we're trying to do.
Yeah.
Okay? And so henceforth, going forward, you've got to follow, again, these rules. One motion, show the motion, the response, and the reply, and then do your notice to submit, then it will come to me. Okay, so we've identified one. Let's move on. I think we're just going over the same ground twice, 3 times. Let's now go over, let's deal with this expert extension that you think you filed, but haven't filed a notice or request to submit on. Counsel indicates that they want, and likely want to handle and respond to that today. So, do you want to address your motion for your expert time extension? Okay, tell me what it is and what you're trying to do. And the docket number on your motion. Again, I haven't read it because a notice to see.
570.
Never given. 570, thank you. Okay, go ahead. So you're asking for, so this request is really in motion. Okay. You want to extend the expert witnesses 14 days from the date you filed it to April the 5th.
From the date of the ruling by you.
Let's see, 14 days from today to April 5th. That's what you're asking. You filed this on March 22nd.
Yeah.
Okay.
But I am under the standing,
Wow.
I miswrote that. I just need 14 days from when you ruled that I could submit the expert witnesses. I just needed those 14 days to prepare those as soon as you ruled that I could have the extension.
Was this time frame, counsel, already passed when she filed this request?
Yes, Your Honor.
Can I read what I wanted to say about it?
Well, what you're saying right here, I'll read it. This is what you filed. I request this court to extend the submission of the expert witnesses 14 days from today, which is March the 22nd to April the 5th, 2024. Now, let's see. I researched the information on expert witnesses on the court's websites and saw that the expert witnesses need to be completed by May the 25th, 2024. Okay? So, May the 25th. That still hasn't happened.
Right.
So you're still, aren't you still within the expert deadline?
No, Your Honor.
Okay.
No, expert discovery began in late January. It's closed in February. So we're months past that.
Okay.
In the court docket,
Defendant was not aware until today, March 22nd, 2024, that her understanding and calculation of an expert witness was incorrect and should have been submitted on an earlier date. So here you're acknowledging you missed the deadline.
right.
Okay? And so you apologize. And then for some reason, you're still saying you have 64 days for the expert deadline?
No, if I could start,
Oh, okay.
on your court, on the very beginning of the court system that I have as a pro se person, at the very beginning, you gave court dates of what you thought it would look like, or the court dates.
Ms. Kamp?
Yeah.
Let's just go to the substance of the motion rather than procedurally the things that have happened.
Right.
Tell me what it is you want in regards to this expert time extension. Are you asking for more time to file your expert report? Are you asking for more time to depose the expert? Are you asking for more time to find an expert? Are you asking for more time to respond to their experts? I don't know what it is you want.
All of the above. I actually, not all of the above. I just want to be able to put into court who my experts are and the documents from the experts, because I did not realize I miscalculated from the date that's on the system that I have as a pro se person. It gives the dates that you, I believe at the beginning of all of this, set forth. all of the expert witness documents need to be in by May 25th, 2024. So I went to the court.
It's automatically generated.
Yeah, so I went to the court website and I read up on expert witnesses and when to have that submitted. And it said 42 days prior to, that's the rule, 42 days prior to have their papers submitted. And that I calculated that out to be 42 days prior. I think it was, I can't even remember. Anyways, it's on the, I believe on the paperwork. So in my mind, I'm like, I need to have all the paperwork that day.
I get it.
I did not know that there was another date that was given that you had to let the court know who your witnesses were. So basically, I just want an extension of 14 days from today to write up the paperwork and submit it into court of who my experts are, and then have the remaining time to depose them or depose his or get paperwork, and we're still months out. So
Thank you. Counsel, your response.
Come up here, Your Honor, so I can talk in the microphone. I didn't quite follow the timelines that Ms. Kamp was discussing.
Essentially, what I'm taking is she wants to reopen expert discovery, and she wants to give a new time period for expert discovery so she can have a do-over and go back to the very front of the line of the expert discovery and push everything off because she miscalculated deadlines and didn't understand it. That's what I'm getting out of the motion.
Yes, that's what I understand too. I think before we get there, just a few reminders for the court. She has had 5 different attorneys on this case. She's had
most of the time and could have done all of this designation at any time.
Exactly. She waited almost a year to do anything in this case at all. That's why we got in that position in November, because they had waited till the last 3 weeks of discovery. The court was very gracious, gave them more time.
Yeah.
And the fact that she doesn't have an attorney here with her today doesn't change any of that. And we have in our opposition case law that has not been opposed that she doesn't get a pass on any of this because she's today pro se. She hasn't been pro se for most of this. I think it's also worth noting, and the court has addressed some of it today, her repeated filings of documents have cost my clients an extraordinary amount of money.
That would go to the award of your fees on your motion. That would
Right.
At the end.
Yes. Yeah, and I just want to highlight that because this is another version of that. Next, we've set a trial date. The idea of reopening expert discovery at this juncture when fact discovery is closed, expert discovery is closed, we have a trial date, is incredibly prejudicial to us. And she hasn't explained really.
Maybe. It may depend upon who her supposed experts are.
Well,
And what would these supposed experts tell us?
exactly.
I don't know.
And I don't either, because that's not the motion. She has not represented the court that she has identified experts, that she's retained them, that she has the money to retain them. It seems extraordinarily prejudicial and unlikely to have all that happen in a way that is fair to us prior to the August trial date. And this is all based on her saying she miscalculated without even explaining what that means. I don't even know what that means or how she miscalculated. Her response was due February 12th. She files her motion March 22nd. So over a month later, before she figures out she miscalculated the dates somehow.
Thank you.
can I respond?
Yes, you get that last word, then I'll make a ruling.
Okay.
Do you want to tell me also who your expert would be and what it is your expert is going to say?
Yes.
And Your Honor, can I say one other thing before you turn the time over to her? We all heard Ms. Kamp a few minutes ago say that she wanted the first available trial date in June. So that really cuts against her need for experts. That would have been even more of an impossibility had you given her the date that you wanted in June.
Thank you. Please.
So yes, I did miscalculate that by what I read on the court website. Sorry, I was thrown off by what he just said. The expert witnesses that I will be coming to court is someone who is expert in finances.
I want a name.
I don't have the names. I didn't bring them with me.
You haven't picked an expert.
I have not retained them yet. I am talking to multiple at the time.
Who?
I didn't bring them with me.
You don't know who you talked to?
I have the names at home. I don't have them here.
Okay, and they're experts in what?
In mental health and finances.
Mental health and finances. Are they accountants?
Yes.
Who? You don't.
I found them on a law website,
Okay.
and I've interviewed them, but I have not retained them because I didn't know if I was going to be able to. So I do have one.
Do you have the money to retain them? If you don't have money for counsel, that kind of implies to me you desire to hire them, but you may not be able to retain the experts?
No, I can. I can do them in small amounts, just like Mark, who came in for one motion for me because I didn't know how to say it in the proper way, and I wanted it to be filed properly, even though I was unfortunately not given that motion to read before it was filed, which I would have liked to, because I could have corrected some things. I still have the ability to hire things when I feel they are very much necessary, like the appellate court appeal. I hired help for that, but I cannot retain a lawyer where I'm paying thousands of dollars every week.
Okay, what is the purpose of the financial expert?
Because John Dehlin is the financial expert according to the plaintiffs. He's the financial expert. He is the only one, according to depositions, that have ever looked at the finances of Open Stories Foundation. The other board members are not allowed that opportunity. And so seeing that he is the only one who has ever looked at the finances for this foundation ever, an expert to go over the financials, since John is actually not an accountant, because they're suing me. For financial.
Let me ask my question
Okay.
so I can understand.
Mhm.
Okay. Why is it important for your expert to look at the finances of this foundation? Do you have a claim against them for that?
Because I know.
Do you have a claim, a cause of action against them for something financial?
Yes,
You do?
they have one against me for something financial, and I'm trying to show that they are lying.
Okay, so it's not because you have a claim, it's,
Well, I do, but you're not accepting the claim.
no, yeah, because you don't have an accountant.
Right, exactly. So it will come in a different lawsuit.
Tell me about the mental health.
The mental health is
Who's going to testify to what and to whom about what?
because of the videos shown and presented in evidence from the plaintiffs. For them, is showing insubordination and different kind of words that they're using. For me, it's a month of mental abuse by the hands of John Dehlin while working for him. I see that video, I see that shaking voice, and I see me standing up to a man that has abused me for over a month and a half as very differently than the way that they're portraying this video to be. And I would like another mental health professional to give their expert opinion on the gaslighting and manipulation and mental abuse within the video and my story.
Have you gone to a mental health counselor?
Yes.
Yourself?
Yes.
Have you been receiving sessions and discussing and interacting with them about this mental health component that you have supposedly suffered at the hands of the plaintiff?
Yes.
And have you had any intention to designate your current mental health counselor as an expert?
No. Because no.
Okay.
Since the beginning of this court case and all the way through it, I have kept my my medical, my husband, and my lawyer privilege, and I am not waiving it.
Okay. Thank you. Counsel, anything else before we move on? I'll give you a ruling on it at the end with all the other rulings.
Just briefly, Your Honor, the mental health is, as we understand, it's part of her counterclaim, which has been rejected by the court multiple times.
And she has to prove the counterclaim. She doesn't have it, so she doesn't need to designate a mental health counselor to prove that her mental health status and condition is part of proving her claim. So a need for a mental health counselor is not.
I object to that. It is very much important. It's what I said. It's what they're suing me about. They're suing me about defamation for what I said. What I said is what I need evidence for to go against what they're saying. It is important. It's what I said. I need the evidence to show what I said is true.
What you need, your evidence of what you said will be your testimony on the stand of what it is that you said.
I know, but you're not letting me have evidence against that, whether in subpoenas or
I'm sorry, Ms.
production.
You don't understand the burden of proof here that we're talking about.
I'm trying to get it. That you're not allowing me to do so.
That's right.
That's right.
That's right.
This is
right. You're past the deadlines. I'm sorry, I'm going to deny your motion for the extension of times for experts here. Okay, we tried to explain to you to have you understand why and the basis therefore, and you're arguing with us instead of trying to understand the basis.
No, I understand the basis. I'm asking for an exception. Sorry, I apologize.
You're talking over the top of me. You're not wanting to hear what it is that I'm trying to explain to you.
I apologize.
Okay? Mm-hmm. All right, ruling's done. Let's move on. Okay. Counsel, we have your 3 motions.
Your Honor, the first one that we think is more of a housekeeping matter that we can hopefully dispose of quickly is our attorney's fee request that you mentioned earlier. The court granted our request for fees on March 7th. We filed our affidavit. It has not been opposed by Ms. Kamp, so we'd request that the court enter that order for approximately $12,000 in attorney's fees.
Okay, Ms. Kemp, do you want to respond to that, please?
Yeah, which one was that?
Their motion for attorney's fees for the expenses that they've incurred in dealing with and responding to
He's already
what is being presented as improper, incorrect, multiple motions.
You've already granted the request for fees.
Yeah.
The order. You've already ordered fees.
Oh, I'm sorry. I thought we were talking about another case that you were still asking for fees on.
No, this one is on the 3 counterclaim. Let me come up here, Your Honor.
The 3 counterclaim requests that we kept saying.
Yes, you've already awarded us our fees. We've submitted our affidavit. That affidavit has not been opposed by Ms. Kamp, so we just need you to sign the order with the amount of the fees at this point.
Okay.
I did oppose that.
Okay, where? So we can look at it.
Okay.
See.
Let me find it, please.
Sure. Okay, Ms. Kamp, again, this is in part some of the challenge of being pro se.
I understand that.
Well, you don't, because I haven't explained it to you yet. What I'm trying to tell you is do you realize that you have the right under the rule? And here this is again, the court trying to educate you and train you to be an attorney, which is really not the court's role. You have under Ms. Kamp, will you look at me? Thank you. You have the right under the rules to review their affidavits of attorney's fees and expenses and file an opposition to anything that of the amounts or the works or the descriptions of the attorney's fees that they requested as not being proper. For example, if they included in their work that doesn't relate to the motions, if they included in their multiple attorneys doing the same work at the same time, that perhaps would be proper. And the fees would be discounted for those amounts of monies, etc. What counsel is saying is, okay, you did not oppose and provide any objections to their attorney's fees in regards to the amount or the work that they performed under the rule. That's what I understand him telling me when he said you didn't oppose the fees. That leaves us in a position to say, Judge, the fees are appropriate, you've ordered them, now award them to us. Okay? You've just said, before we go, I want to see whether or not you filed a response or an objection to their attorney's fees. You said you did. Could you show us where that is now? So we can see what it is that's improper about the calculation of their fees.
I think I might have been mistaken that with another ruling, unless that's the one that I asked for extension from Shane and he gave it.
That was
But
not that
I think
one.
I'm mistaking that with something else.
That was something else.
Okay.
I don't think that I knew that I could go over the fees and object to a fee thing that you've already ruled on. I thought the ruling was the rule and then you got to choose.
Again.
May I approach
Thank
it?
you. You may. All right, so there's that basis, then the court's going to go ahead and approve the order for the award for the attorney's fees. Counsel, I'm not going to put a time limit on the order. You simply get your judgment. I'm not going to order her to pay within 10 days, and then hold her in contempt not to pay the attorney's fees. Okay, we're not doing that. She orders you attorney's fees, you get the award of attorney's fees as a judgment. You do what you need to do to try to collect it, whatever manner or method that you can. Okay, so I'll make a modification to that. Okay, your other two motions?
Your Honor, we also have a privilege waiver motion. And I think just briefly before we get into the privilege waiver one, it would be useful for the court to know and to remember all of these things we're dealing with are completely avoidable. Ms. Kamp sued our client in federal court for sexual harassment with baseless claims. It was dismissed. We have repeatedly told Ms. Kamp we could resolve this case if she would recant her defamatory statements. She's refused. We've tried to mediate this case with Ms. Kamp. She's refused to do that.
That's not true.
She's filed endless motions, which at this point we consider vexatious litigation, and increased our costs by over $100,000. So my clients are very upset to be here. In terms of the privilege waiver motion, there are no disputes about the case law regarding privilege and the waiver in this case. There are no disputes that Ms. Kamp has repeatedly disclosed otherwise privileged communications with her attorneys and her spouse. All of that's undisputed. I think the only thing that is disputed is her justifications for doing so. I think it would be helpful, Gerardo, if you can pull up. I want to show the court a few of the disclosures. I don't want to waste the court's time, too much time, but I do think it would be helpful to go over a few. Over the course of this litigation, Ms. Kamp has disclosed otherwise privileged communications in almost every conceivable way possible. She has disclosed privileged communications on her podcast. She's disclosed them to her friends in text messages. She's attached them to motions as exhibits. She has testified them about privileged communications in depositions. She's testified about privileged communications in court, and she has disclosed them in her disclosures to discovery. So there are 6 different categories of ways she has repeatedly disclosed attorney-client privilege communications, including while she was represented by counsel. That's most, if not all of these, have occurred when she was represented by counsel. Gerardo, if you could go to 22, let's start there. I'm just going to show the court a couple of these so you get a flavor. These are all attachments to our motions, so the court can look at these more easily. 22 to the slides. Oh, it's not working? Okay, let's go back to slide 1. The one I was going to show you, Your Honor, which has been submitted to the court, the waiver of the privilege has been so extensive. At one point, she filmed herself texting her attorneys about the case, and that has been published. So these are not situations where she has accidentally made disclosures. These have all been very intentional, and they've been over a long course of time, and they've been under when she's been represented by counsel. Let's see if this one goes. Try to hit that. All right, Your Honor, if you can see this. This is her videoing, texting her attorney.
Typically, I would take
All right, Gerardo, if you can go back to the first slide.
In talking to my attorney, he stated we could move forward. However, it would be an uphill battle with the law in Utah protecting 501c3 foundations. This law states that if a foundation has less than 15 W-2 employees, they cannot be prosecuted for sexual harassment, retaliation, and wrongful termination.
Go to the next one, Gerardo, if you could. So there are several of these on her podcast, Your Honor, where she openly talks about what her
It will
attorney
forever
have talked
be
about.
filed with the state and not served. Though I would be paying my lawyer out of my own pocket, my lawyer says his guess just to try the lawsuit will be years in the court system and upwards of $200,000 or above for both sides.
Gerardo, can you go down to 4, the text messages? And there's more video, Your Honor. We're just not going to go through every one. Number 4 on the slides.
Slide 4.
Yeah, slide 4. Or no, it's 5. Sorry, my eyesight's bad. That one. This is a text message with her lawyer, Christopher Snow, that she attached an exhibit to her stalking petition. There's several of these. If you could go down, Gerardo. She routinely attaches these text messages and communications with her attorney to her filings. This is another set that she attached in this case as an exhibit to her third motion for leave to amend on the counterclaim. She specifically says, my lawyer's response regarding the lie of and Reddit post above, retraction was never made. He continues to say this lie, even though he has evidence below to this day. She attaches text with her attorneys. This category, Your Honor, is her texting her friends. She has a group chat called Badass Bitches, and she routinely texts her friends about what her attorneys have told her and copies text messages from her attorneys to her friend group, which includes several donors to OSF. go down, or go up to the court testimony one, Gerardo, yeah, that one. She's also talked about attorney-client privilege communications at her stalking injunction, telling in open court what her attorney has advised her and told her. If you could go down the next one, Gerardo. During her deposition, she's also talked about what her attorneys told her. In her opposition on these ones, in terms of her court testimony and deposition testimony, she basically says her attorneys, I think, and she can explain better, I think she's taken the position that her attorneys messed up by letting her testify about privileged communications in these hearings and depositions. That doesn't protect, I mean, that's not our issue to deal with, really. That's her and her attorneys. This is more of her deposition testimony. This was an email that she produced in discovery in this case. This one is interesting, Your Honor. This case started with a demand letter from her attorney contending that Mr. Dehlin had showed her a pornographic video. In her deposition testimony, she recanted that and said that she had never told her attorney that Mr. Dehlin had showed her a pornographic video. And then she produces an email to her attorney where she attaches the video to her attorney saying, "Music video John had me watch until I walked away." So she started out saying, "Pay us money because John showed me this video." Deposition retracted it, said, "I never said that. My attorney must have just put that in the demand letter without me knowing." Now we have an email where she actually gave the video to her attorney, and it's titled "Music Video John Had Me Watch Until I Walked Away." So the categories and extent of the disclosures in this case are over the course of a year. There's not one of these that is inadvertent. The only one that Ms. Kamp even hints at being inadvertent is in a more recent disclosure where she disclosed communications with her husband and attorneys from Mexico. In her opposition, she partially blames the court for that because the court didn't grant her an extension, so she was disclosing documents from Mexico. When she first responded when she first reached out to us, she said, "Hey, I've included some recipes and first recipes in that disclosure. I'll get rid of those." She doesn't say anything about the text with her husband, which you're seeing now on the screen, or her communications with counsel. It's only later in a meet and confer with Ms. Tomchak, where Ms. Tomchak explains to her that by her continually producing all this stuff over the last year, she's waiving these privileges. That's the first time in this case where she says, "Oh, it was inadvertent." And the case law is really clear on this stuff. It's not, Utah law doesn't say, it says if you intentionally publish or disclose confidential privileged communications, it's a waiver. It doesn't matter if you fully understand the legal implications by doing so. It's only if the disclosure itself was intentional. And there are so many disclosures here in such a wide variety of ways. It's impossible for Ms. Kamp to say that these weren't intentional. I think what she says in her brief is she didn't understand it, what the legal implications were, and that is not enough to save the waiver of her privilege. And the case law in our briefing has went unopposed by Ms. Kamp in that regard, so I don't think we have any dispute on that either.
That's true.
We think it'd be incredibly unfair to let Ms. Kamp, and the reason why she's attaching all these things and referencing them in her testimony is because she thinks they help her case. And so the court knows it's improper for her to be able to use these communications as both a shield and a sword. And there's one other secondary piece to all this. In some of her deposition testimony and elsewhere, she's raised the defense of advice of counsel. Well, my counsel told me this, my counsel told me that. That's a secondary, entirely separate from the disclosures, reason that we're entitled to these communications with her counsel, because she's now putting those at the forefront of the case, kind of blaming her prior attorneys for advising her on this stuff. And you're looking at some of this right now on your screen where she's raising this advice of counsel defense. So we think we're entitled to these communications, both on her disclosure of otherwise privileged communications and the advice of counsel defense. Nothing further at this point, Your Honor, unless you have any questions specifically about any of the disclosures, we can go over them.
No, thank you.
Thank you.
Do you want to address one issue, the overlength response?
Yes. Yeah. The response. Yeah. The response was after it was due, and it was over length, but I think it was 7 pages, and so yes.
Thank you.
Thank you.
Please.
I'm just going to address your last thing first, if that's okay. The overlength, according to what I see on the website, is that the statement of discovery issue cannot be more than 4 pages long. So 4 pages, but the plaintiff's initial thing was 7 pages. Mine was 9 pages. So it looks like we both went over pages on this. They also have argued that I didn't reply in time. I did reply, and I received an extension from Shane until March 25th, and I did reply by March 25th. He says that I didn't just now, but I have the email from him letting me have the extension to the 25th if you'd like to see that.
Your Honor, I did give her an extension. If that's the one, then we will acknowledge that.
Thank you. Okay, and your response, let's see. That's this one, repeated response to the repeated motion of plaintiff's motion for order to show cause and support. No, that's the wrong one.
No, this is just response to plaintiff's SOTI privilege waiver.
Okay, and let's see where that was. Page 75. Thank you.
I tell you, I don't,
Yes.
on the pro se site, they don't give me docket numbers, so.
They're on the, thank you. Okay. Well, do you want to tell me?
Yeah. So the plaintiffs, let's see, I already went over that.
Okay, the bottom line here is, and what I need to have you do, they're telling me you've waived your attorney-client privilege because you've talked about it numerous methods, numerous times, in numerous manners.
Okay.
Okay? Your response is basically somewhat of a general denial. I still retain, my right to protect my privilege. You can say those kinds of things.
Right.
You want to address whether or not what you did and how you did it and when you did it
Yeah.
does or does not qualify as a waiver of your
Yes. All the
privilege.
right.
That's what
All of the text messages between Christopher Snow that they're showing as evidence were placed with a stalking injunction order that I received in February of 2023. At the time, I didn't have counsel, and I didn't know that would waive any right. Those were placed.
You don't deny they were disclosed.
Right.
You're just saying you didn't know the law that
Sure.
disclosed them.
Exactly.
And that's your defense.
No. Well, for what I'm saying is that those were placed into court. They were, the only reason they were used repeatedly and shown repeatedly is because Jenn Kamp questioned me about them in my deposition, and she told me I had to answer every question she asked, even if my attorney objected to it. And so I'm following her, what she told me to do. And so if me answering her when she told me, even if my attorney objected and I still had to answer, is now what we're using to say I don't have privilege anymore, is kind of not okay.
Depends what the objection is. If it's an objection because it's attorney-client privilege, that's one thing, and you don't answer. If it's an objection on the basis of something else, that it's irrelevant or that's something different.
Okay, so I placed those text messages, not knowing, into evidence in a stalking injunction trial. Those, or a stalking injunction that I received in February of 2023. Those were used in court. Judge Sanchez did not waive my privilege, even with them being submitted in that court. I didn't know at the time that that's what would happen. I was just trying to show, as their retained lawyer, is downloading evidence from this trial that is submitted, and he is podcasting about it and monetizing off those podcasts as from the last 14 plus months.
Okay, let's stay on the attorney-client privilege.
Well, that's what the text messages were about. So I unknowingly did that in the stalking injunction court. Why they are coming up over and over again is because they are bringing them up over and over again. And I am trying to fight against that in my counterclaim and in other parts. And so the evidence from the stalking injunction trial is coming into play.
Okay.
That is why those text messages.
I've got that.
Okay.
You told me 3 times. I got inadvertent part of the stalking injunction you didn't know.
Yep.
Okay, what else? What about the other manners of disclosure?
Yes, I don't know, can you bring them back up and I'll go through them? The ones that he showed?
Well, I think
The other ones he showed was in my deposition, and my lawyer was sitting next to me. He objected at times. I have the evidence.
What was the objection?
Lawyer-client privilege.
He did?
Yes.
And he still let you respond?
On one, he objected after I responded, and on another, I don't know, I brought them with me. I can give them to you.
Okay, I get what you're saying. He may have on some occasions raised objections, on other occasions he may not have.
Correct.
Okay. Next.
And then talking about when I was in Mexico, and asked for an extension from the plaintiffs that they did not give me. I asked for one from the court that I didn't get. When I was in Mexico, I had an unsecure Wi-Fi, and I sent all of the evidence because I knew it was due on January 15th. I didn't want something not to be sent and then me not to be able to use it in court. So the plaintiffs. So I sent them my Google file that had all the evidence in it because I didn't want to not be able to use something, and I wanted to do it according to the court's dates. So I sent that from Mexico. When I sent it, it attached a file that was not supposed to be attached. Within the file, there was a few pictures. There was the video from the stalking trial where when I was recording my phone, partway through the recording of the recording that I was doing on my phone, my lawyer's text messages popped up, and I hurried and responded to him and then turned it off. So that was included in there. There was also a couple text messages between my husband and I. There was also baby shower invites and spaghetti sauce recipes and my family's pictures and medical papers and all these things that were in this totally separate file that when I sent them my Google file from Mexico, that was not intentionally attached to it. So when I noticed this, when I got back, I have the emails, I sent the plaintiffs, I stopped their ability to be able to look at the file, and I let them know that I would take out the items that were not meant to be put in there. I laughed with them. I told them, you can keep the spaghetti sauce recipe, it's really good. And it didn't seem like a big deal. It seemed like they were going to allow me to take out the things that weren't supposed to be in there, and then I would give the file back to them. They understood it was not intentional, and it was because I'm guessing the network I was trying to use there.
How do you know they knew it was unintentional? What conclusion do you point to?
Because we laughed about the spaghetti sauce recipe being in there and my bridal shower invites for my daughters and like things that were like totally out of character, that there's no way I would include them in an evidence file.
What about the disclosures of the attorney-client information? Did they tell you, oh, we agreed with you, that was unintentionally given to us?
No, they said that they just said I could take the things out that weren't supposed to be there, and then I could reopen the file for them.
Who was they? Which?
Jenn Kamp.
Okay.
So that's what happened with the unintentional things that they showed here. I did and have always stated, even in my deposition, that communication with my husband or him in this lawsuit of any way is I never wanted. Okay. Let's see. In evidence B, highlighted as it's like paragraph B in their evidence. There's highlighted row 7, 8, and 9. I was not talking about my lawyer here, but of the plaintiff's retained lawyer, or what he goes by Radio Free Mormon. I was talking, so anyways, they have it highlighted, like that was my attorney-client privilege. I'm not even talking about my attorney. In lines 18 plus that I have highlighted in my deposition are intentional questioning by Jenn Kamp about the stalking protection order evidence. And so I answered her regarding the stalking protection order evidence. So I don't agree with her asking me the questions, telling me I have to answer them, and then using that against me. In D, the privilege was not waived, and again, responding to questions by Jenn Kamp, even though she was already warned by my lawyer that I was retaining my client lawyer privilege, she still continued to ask the questions about my lawyer. In E, F, and G, the email to plaintiff's counsel stating the mistake and how the mistake happened. I have that email with me if you'd like that. So in B, let's see, the plaintiff did not fully comply with discovery until December 19th, 2023, stating they had asked for a privilege to withhold evidence from you that you had not ruled on. So they had extremely important, let's see, sorry, I'm trying to see why I'm saying all of this. I think I'm just telling them what I've already told you about all the things that happened in those 20 days that I was supposed to get all this, do everything. It's superhuman. So I'll just skip all that. Let's see, when I sent the documents from the unsecure network, I detached them. I told them that I would redo the file, I would bait stamp it because they've been asking for me to bait stamp the evidence, and then I would get that to them by the 15th of April. When this court date came up, I asked for an extension to the 30th of April.
Which they gave you.
Don't know, did you reply, Shane?
Yeah, I thought he acknowledged he gave you the time frame.
Yes. Yes, Your Honor.
Okay. Anything else then?
In paragraph C, this is a vague statement that does not release lawyer-client privilege. Jenn Kamp was asking if this statement was read by my lawyer, and I was answering her, yes, it has been read by Hepworth Legal. And then Hepworth, or I stated Hepworth should have objected. This is a repeat, paragraph I. This is a repeat of the above stalking injunction trial evidence that was submitted before I knew about privilege and what that entirely entailed, which wasn't until recently that I understood the rule when I was forced to go pro se. Plaintiff's counsel continues to lie, I use the word lie, to the court and the public regarding my statement in January of 2023. I have never, nor did my lawyer ever say to me or anyone else that I would, quote, not win a lawsuit against John Dehlin and Open Stories Foundation. Never has that been said or even alluded to by me. I was speaking about the cost of litigation in the lawsuit I am placed against John Dehlin and the Open Stories Foundation, and how I did not feel it was right within me that John and the Open Stories Foundation used donors' money given to them for the post-Mormon community to defend themselves against the abuse and harm I experienced by working closely with John Dehlin, and the retaliation I received when I went to the board with help regarding the abuse and harm. So I was speaking about the cost of what it would cost the donors, because they're funding this lawsuit for them. I was speaking about in general. I was not speaking about any exact wording or things like that. I was trying to explain why I wasn't going to sue them any longer, why I had stopped that lawsuit. That's all I was doing. My communications with my lawyer, even though some were submitted as evidence before I knew about the waiver of privilege, were kept intact by Judge Sanchez. Never did she rule against me that the lawyer-client privilege was now waived in the stalking injunction court, and it should not be waived now, in my opinion, because of reusing it by the plaintiffs and myself now. There was only one person who happened to see, they talk about within the motion, but he didn't bring it up today, so maybe I won't even talk about it if he didn't bring it up today. But I just want to restate that for me and all the evidence I've collected and knowing the truth, there's no defamation in that video. So, and that's going along with, I guess, number 15 that he didn't address. So maybe I will not address it.
Thank you.
Do you want copies of the evidence that and the emails that show me from reaching out about the accident?
Sure, I am interested in the response from counsel about Ms. Tomchek supposedly telling you they acknowledge that you sent some attorney-client privilege by mistake and you would be entitled to withdraw it. So if they deny that, maybe we need to look at the exhibits.
Well, the email...
Well, we can show that to Your Honor when I get up.
Okay, either way. That's fine. I may look at it. Let's see what they say. Let's see if they acknowledge it or if they don't. Counsel, and then we've got to go to the other motion.
right, Your Honor. On your screen is the email that Ms. Kamp was referring. On your screen is the email Ms. Kamp was referring to, I believe. This is after she sent the file folder she's talking about. If you see the second paragraph down, she says, "Please disregard those and delete them. I see my niece's baby shower invite, my daughter's school schedule, etc. I'm going through it right now to take out duplicates and the images that somehow were somehow attached to this folder." So she doesn't mention anything in the email about inadvertently disclosing any communications with her spouse or attorneys, and doesn't remove any of those. The first time this comes up is on a meet and confer call with Ms. Tomchak much later, where Ms. Tomchak informs her, "Hey, you were continually waiving the spousal and attorney-client privilege." That's the first time she starts down this road of, oh, it was all inadvertent. It clearly wasn't. This happened over the course of the last year. This is just the latest version of that. And even this version was not inadvertent. The only thing that was inadvertent on this one was the spaghetti recipe, the shower invite, and her daughter's school schedule, according to her own email.
It says I'm still going through it. Also in the email.
In addition, Your Honor, Ms. Kamp doesn't address her disclosures on her own podcasts, the attachments to her motions, the disclosures to her badass bitches texting group of friends. What she does say is today in court multiple times, "before I knew." And I think that's the primary defense she has, "before I knew." As we've already talked about, she's had 5 different attorneys for the last year. And so it's not a defense either under the case law or just the facts of this case that before she knew. That's not a valid defense to waiver of the attorney-client and spousal privileges. And she does not address that fact either today in her hearing or in her papers to the court. If we could go to slide 18, Gerardo. These are some of the text messages that she's disclosed with her husband. This is further evidence that they were not inadvertent. She redacted those text messages, Your Honor. So it's hard to imagine it was inadvertent when she redacted specific pieces of the text messages with her husband before producing them. Gerardo, can you go to the court testimony or the deposition testimony slide? She talked a lot about Mr. Hepworth in the deposition and said that he did object some of the times, other times he didn't object. This is one example. You'll see no objection from Mr. Hepworth here. There were times where he did object and Ms. Kamp refused to testify when he objected. There are a lot of other times where he didn't object and allowed her to testify, and she did testify. And so she can't
Pick and choose.
Yeah, she can't pick and choose when it's helpful for her to testify as to something that she thinks can help her case, and then in other times try to withhold information that's not helpful to her case. I think that's all, Your Honor, unless the court has any specific questions. All right, thank you.
Okay, that then leaves us for the remaining thing today, and that is this new motion.
Can I say something about the attorneys that they keep saying that I think is just manipulation?
Normally, it's they get to say, you say, they respond, that's it.
Okay.
But if you have something very, very brief, 30 seconds or less, then
15 seconds or less.
go ahead.
They keep saying I've had 5 different attorneys during this court case. I think it's just a form of manipulation to seem like no one wants to work with me. It was all the same law firm, and except for when I've been pro se, where I have at times paid for an attorney to do one thing for me that when I thought it was very important. So I just wanted to state that.
Thank you. The fact that you had attorneys is not being held against you.
Well, it seems like in the way they're presenting it, it's for manipulation of people listening.
Okay, thank you. Okay, we have a motion for an order to show cause and a request for spoliation sanctions that has been fully briefed. Is there any objections? I did not set this one up for a hearing today by giving everybody notice, but I can do that if you want to come back on another day, or if you're ready or prepared to argue your motion and the response today, we can do that, and I'm fine with proceeding today on it. But I don't want somebody to claim foul play by not having time before a notice of a hearing to address this before the court. So, Ms. Kamp, that is to you. Are you okay? And you willing to go forward and argue this motion for spoliations and so forth today, since we're all here? Or do you want me to set another date and everybody come back and we argue only this motion? What would you prefer?
Can I ask you a question?
Sure.
After we argue the motions today, can they be redone?
No, it's your
Are
motion. It's
Are we, after, I guess what I'm asking after this hearing today, is everyone done putting in motions? Like, are we done?
That's my understanding.
Okay, I'm greatly happy for that.
Okay.
I'm fine, let's do it.
That doesn't mean that you or they can't file future motions.
Well, that's what I was asking.
No, what it means is we're caught up with all motions in the case and we're done.
Okay,
There's nothing pending, nothing briefed, nothing in the hopper, nothing to decide.
okay.
So
I'd
we
rather
go
just
forward?
get it done today.
Okay, Ms. Tomczak?
And just to make sure, Your Honor, I think that,
Again, they were just given to me yesterday. I will read them.
okay,
I'll read them while we're talking, so to make sure what you're doing. So you can touch on what you have in your motions because I haven't read them.
Great.
I won't get mad at you for doing that.
thank you. I appreciate that, Your Honor. And I think, I just want to make sure that we're talking about the same. So there are two separate motions. There's our motion for,
Comply with the court's order dated March 8th and the spoliation of evidence. That's the
yes,
other one I-
okay. So there's the motion for order to show cause and spoliation sanctions that was filed on April 16th. And then there's Ms. Kamp's motion for sanctions.
Is there another motion?
So there's one that's been fully briefed and submitted, and that's the motion for order to show cause. And then she's also filed a motion for sanctions regarding spoliation and withholding evidence in award of attorney's fees that was filed on April 17th that hasn't been briefed. But that's the one that you heard argument earlier on about the surveillance footage. So I just want to make sure that we're talking,
Nor is there a request to submit on that one, but we
right,
need to.
there's not, but we are
deal
prepared,
with
like, we have argued it and are hoping that we don't have to file a response to it.
Okay.
Okay, so on the motion for order to show cause, our motion for order to show cause, Open Stories Foundation, like the court, would prefer to have this case resolved on the merits. But Ms. Kamp's continued violation of the court's repeated orders and intentional concealment, withholding, and intentional or reckless spoliation of critical evidence has made it Open Stories' ability.
How do you know it's intentional versus just she can't get to it because she's overwhelmed and doesn't have the time?
So I will show you the evidence to support that. But in addition, under the case law, it doesn't matter if it's intentional. Even inadvertent spoliation, even negligent spoliation of evidence is grounds for spoliation sanctions because under the, I think it's diversified holding, let me give you the diversified concepts versus Cofer. This is 2021 Utah Appellate 71, paragraphs 22, 34 through 38. And what it essentially says is that when a party has been prejudiced by the loss of evidence, the person that has to be held responsible for that loss of evidence is the person in the best position to keep that evidence, to make sure that that evidence isn't spoliated.
But don't we have to know what evidence was exactly lost in order to understand the consequences or the impact or the severity, the loss of that information on the case itself in order to justify what the appropriate sanction is?
Yes, Your Honor. You don't need to know exactly what the evidence is because there's no way for us to ever know what the evidence is if it's lost. But you need to understand what the importance of the lost evidence is, and we will address that specifically. There are 4 categories of documents that...
Okay, didn't mean to cut you off, but I wanted to give you a heads up before you get there because it's important to me to understand, because you've asked for a range of sanctions, and I need to feel comfortable what the appropriate range of sanctions is. And that includes anything from instructing the jury to infer it against her to, I think you believe, asking for dismissal of the case.
Yes, Your Honor. And I think that
Not dismissal of the case, but judgment against her.
Right. And I think going through this evidence will give the court a good understanding as to why we're asking for those sanctions. And specifically, it's because we cannot receive a fair trial on the merits given just the vast number, the amount of evidence that we know for sure that she's withheld and is spoliated. And under the circumstances that this happened, we're also unsure what other evidence she's concealing or withholding. So I think what would be helpful to the court, if I may, is to go through the evidence. So the first example that I want to talk about is her recording with her husband, Jenn Kamp. We requested in our very first request for discovery, so this was in May 2023, all recordings and all statements that she had made about plaintiffs and about any of the allegations made in her defamatory statements or in the lawsuit. We did that both for a request for production, asking for the actual documents and recordings themselves, and in an interrogatory asking for an explanation and identification of any documents that were not in documents. And in addition to that, we had an instruction that says, if there is any evidence that is not available, please list it and explain to us why it isn't available. And the reason we have that instruction is so that someone down the line doesn't come back and say, oh, I didn't produce it because I didn't have it anymore. It gives them an obligation to identify the information in response to the discovery request. She did not list the recording with her husband, or a 2-part recording, a 6-hour recording, and then there's a 3rd recording reading public statements. She did not list those, identify them, any way disclose that there were these recordings that she was holding back and not disclosing. The reason we found out that she had these documents is because she included them in text messages with her friends. She talks about them. This is slide number 40. She talks about them in communications with her friends, talking about a podcast that she recorded with her husband. And
was this during the time frame in which she was represented, so we could see that part of the fault for not having them disclosed was on counsel, or was this when she was...
So you can see that this text message where she's talking about her having recorded this earlier this week. We recorded this, and the date of that is, I believe, February 16th, which is roughly 2 weeks after this case was filed, a week after she was served. So, and I believe either at the time or close in time to when she was represented by counsel. But I think it's important to remember that she had been represented by counsel earlier, on September 15th, 2023, so months before this. And I'll get into this more later with some of the other evidence. We exchanged preservation letters, and her attorney sent a letter saying, preserve all the evidence. And we responded on October 23rd with a letter that said, we've already seen...
22nd.
October 22nd? I think it's 28th. Okay, so here's the September 15th letter. Oh, 2022. I'm sorry, Your Honor. I'm getting my years mixed up. So before the court right now is the letter, an excerpt of the letter from her counsel, talking about everything that they need everything that needs to be preserved. And notice that this is at least 4 months before she's recorded this podcast with her husband. And then if you'll turn to the next slide, on October 28th, we tell her counsel, look, we know she's already spoliated evidence. And we want to make sure that moving moving forward, she preserves any and all evidence relating to all of this, including specifically her defamatory statements on social media, any drafts or scripts. So by February 17th, when she has been twice told about her preservation obligations, has been served with a copy of the complaint in this case, she records this podcast with her husband. In response to discovery, she doesn't identify that podcast. She doesn't identify it or several other recordings that we found out that she kept. Those ones now have been disclosed after numerous motions to compel, meet and confer efforts. Those ones have been produced, but I'm getting a little bit ahead of my health self. So when I meet and confer with her, not her specifically, but with her counsel about these documents that she's referenced, or these recordings that she's referenced in her other documents, the excuse they give for not producing them, an excuse that wasn't in their response to discovery, was, well, they're private, because she didn't show it to anybody. And that's the same argument that she made in opposition to our statement of discovery. She said, I don't have to disclose this and these other podcasts or these other recordings because they're private. Well, we found out from other documents that she'd produced that some of these recordings that she claimed were private, she'd actually shown to other people. And they had been viewed by other people. So now we have two reasons to not believe her, right? She's concealed the evidence. Then she says it's private. Then she says, I haven't shown it to anybody, but we find evidence to show that she has actually shown it to people. So we filed a SOTI. She objected, a statement of discovery issues. She objected to producing the recording, saying it's private. I don't have to produce it because it's private. We responded with the case law that says privacy is not a proper objection to producing documents in discovery. The court agreed and ordered her to produce it. This is docket 550, paragraph 1, subparagraph B that you issued on March 8th of this year. She still did not produce that recording. But notice, and this, so the screen before you will show you how her position about what happened has changed. So when, as part of the court's order, it ordered her to file a certificate of service, or not a certificate of service, an affidavit, saying I fully complied with the court's order. I've produced these documents. So she files that affidavit, and in her affidavit that she files with the court, she says, we never even recorded this. This recording that we have a specific reference, because you can see in her February 16th text, with an Open Stories Foundation donor, her saying, I recorded it last week. Then she says it's private, I'm not going to produce it. And then she tells the court in her affidavit, well, I never recorded it. That's the same thing she says to me when I meet and confer with her about it. And I remind her, we have this February 16th text where you specifically state that you recorded it a week before the February 16th text. So then we filed the motion for order. Then she says, and this is on March 19th, 2024, actually, we deleted the video. We deleted the video. So then I filed the motion for order to show cause because she clearly has deleted evidence after the court ordered her to produce it. We don't know exactly the date when she deleted it, but she didn't say that she deleted it until after the court ordered her to produce it. And we file a motion for order to cause that says, look, and for spoliation sanctions, because clearly she's deleted this video. She deleted it after the court case had been filed, and she deleted it knowing that it was potentially relevant to this lawsuit. So then, in response to the motion for order to show cause, so you can see this at the bottom of the screen, on April 18th, 2024, she changes her story again. And now she says not that she deleted it, but that it was automatically deleted by the recording studio online software. So now there are 5 different versions of what has happened to this video that she still has not produced. Now this evidence strongly suggests that she is lying at some point, that she's not being truthful with the court, and that she allowed this evidence to be spoliated. I do want to point out that this statement she made on April 18th is the exact same excuse she gave on our earlier motion for order to show cause, when the specific comments that we asked that she hold and not allowed to be deleted, she allowed to be deleted. She says, oops, they were automatically deleted. So this is not the first time that she's used this excuse and has blamed technology, but it's very telling from the way that her statements have changed throughout that is not an accurate representation of what happened to this podcast that she hasn't produced. So now let's switch to the second item of evidence that is at issue in this motion for order to show cause. Do you have any questions about that, Your Honor? Okay. So this is a text thread that she has someone has titled the Badass Bitches text thread. I'm going to refer to it as the Waka group text, just to cut down on the swearing in court. But it follows a similar pattern. Once again, she was specifically requested to identify all of the communications that she had related to John Dehlin or the plaintiffs in our very first discovery request, with the request for production of documents and with an interrogatory to explain anywhere that was not reflected in the documents, and with an instruction that says if any of this evidence isn't available, identify it now so that we know that this isn't available. She does not identify or disclose that she has had this communication with the group of OSF donors that are in this text message that's before the court. And something that's very important here, Your Honor, is that the excuse that she later gave after we found out that there was this text thread, the excuse she gave for not producing it is that she claimed that it was encrypted. She claimed she didn't have access to it. But if you look through the text, which are the entire thread of the text are attached to our motion, you can see that she is continuing to participate in that text thread until June 8th. June 8th is a very important date here because her discovery responses were due and provided to us on June 23rd. So she, just weeks before her discovery responses are due, is participating in this text thread. And she talks about in the text thread that she may have to produce it, that she may need it for evidence. She says it in a way, well, I'm not going to produce it unless I have to, which kind of gives you a sense of what she was intending to do with this. But she clearly knew about it. She clearly knew about it just before she gave her discovery responses, and she never identified it. She never identified it. And she still hasn't produced her version of it. The version we have is a version that she got from someone else in the text group. But even more alarming than the fact that she concealed the fact that this even existed, and then withheld it as evidence until I believe we got it. What date did we get it? Do you remember? I think we got it in March. So of this year. So after discoveries ended, after the court issues an order to compel, we finally get this. And when we get it, there are so many unsent messages where she went in, and the context shows that people are responding to her. So you can see on the screen, here's just a handful of some of the unsent messages. And they're talking about John Dehlin. They're talking about what happened to her. They're saying, I'm so sorry, Jen. I'm so sorry that happened to you. And you can tell from the dates of when we can't tell exactly when they were unsent, but every single one of those messages was after September 15th. And remember, September 15th is the date that her counsel told all of us, we need to preserve all the evidence. And that's several weeks, well, at least a couple weeks after she'd threatened this lawsuit. So litigation was reasonably anticipated at that time. She knew she had an obligation to preserve. She didn't even disclose it in her discovery. The only reason we found out about it is because we found other evidence referencing it. And then she gives the same excuse. Well, it was encrypted. But that doesn't excuse why she didn't disclose it in her written discovery responses, in her responses to interrogatories, or in the instructions that said evidence that's not available. And this, I think, really goes to the heart of why terminating sanctions are appropriate here, is because we will never know exactly what it is that she said to these women about John Dehlin and what he supposedly did to her. We can give an adverse jury instruction, and the adverse jury instruction can say that these texts that she allowed to be spoliated contain defamatory information, but that is not going to have the same impact on a jury, especially when they're assessing the amount of damages, as I'm sorry, Your Honor.
No, go ahead.
Oh, sorry.
The question I have is it possible to get the full text messages even after they were unsent from the people who had received these messages in the first place from her? So we can find out what was in fact said.
My understanding.
Is that still preserved?
My understanding is no, that when she, so for example, this text message, this is what she sent to us, and she said that she got it from Gabby Accord, who was someone else who was on this text message, and it shows unsent on her end as well. So my understanding is that no, these are no longer available for, when she unsent them, they're gone. Yeah, she unsent them, they're gone. So when a jury is considering the impacts of what it is that she said, it's one thing to advise the jury, like these text messages that she spoliated, sorry. And I will note that people on this text thread immediately started canceling their donations. She specifically tells them how to cancel their donations and started canceling appearances that they had on Mr. Dehlin's podcast based on what she said. But we will never know exactly what she said because she deleted it. And that's something that she has to suffer the consequence of. It is unfair to my clients to not be able to show exactly what it is that she was saying about him. And it would never have the same impact on the jury to just give an adverse inference and say these contain defamatory statements. Because obviously, them knowing that there were defamatory statements is not going to be as impactful to them as if, for example, it said what we believe she was telling to people, which is, he made me watch a pornographic video, he sexually harassed and assaulted me, he sexually abused 19 other women in a pattern of 12 years. We don't know, and we will never know, because she's the one who spoliated this evidence, and she's the one who should suffer the consequence of that, not my clients. There is a third category of documents. This one is a little bit different because it hasn't been spoliated, but the court has twice ordered her to produce bank statements. She has not produced them either time. The court, in its ordering her to produce all these documents, warned her that she would suffer, that it would consider spoliation sanctions if she didn't comply with the court's order. And I think it's very telling here. Her response to our motion for order to show cause related to these bank statements is, I did produce them. I've repeatedly said I produced them. I produced them. I produced them. She's so adamant about the fact that she produced them. But if you look at what she actually produced, it is not consistent with the court order. So you can see before Your Honor, this is what she produced. She produced this after your first motion, after the first order compelling her to produce bank statements. This is what she produced. It's nothing that anybody could characterize as a bank statement. It appears to be a heavily redacted Excel spreadsheet. And this is what the court said about it when we filed our motion to compel, saying you still have not produced bank statements. The court said specifically, I think this is it's slide 54. Slide 54. The court said specifically, such production shall include the actual unredacted bank statements and not the heavily redacted Excel spreadsheet from an unidentified source that Ms. Kamp previously produced. The court has previously instructed Ms. Kamp to produce these documents. So twice now, the court has ordered her to produce these documents. You've given her very specific instructions about what that can and can't entail, and she still hasn't listened to it. So this shows, all of these show, and I do want to note too, so I think this is also an important fact about these bank statements, is that in our initial request for discovery, we asked her to identify all of the money that she's gotten from anybody related to her defamatory podcast. And we asked for the bank statements there. She doesn't produce the bank statements. She doesn't identify any payments that she's received. And only after we've filed a SOTI does she then admit, well, I received one payment. And then she later says, well, actually it's more like $1,000 worth of payments or something like that. But there is a slide, let's see.
Let me ask you this. Have you made any effort to try to get the bank statements directly from the bank?
We didn't.
She hasn't complied.
We did not, Your Honor, primarily because you ordered her to produce them and she didn't produce them. And, I mean, obviously there are additional costs associated.
There's still a remedy to do.
Right. This one does have a remedy. The court can order her for a third time to produce the bank statements and to award us attorney's fees for the efforts that we've had to expend to get these.
Order you to get them and make her pay all the costs associated with it, including the copying fees and expenses that the bank's going to charge you for producing the documents.
Right. Some of the accounts that she's used, can you turn to the slide where it shows the accounts that she's used, are ones that are notoriously difficult for getting statements from a subpoena. Venmo, and the Mountain American Credit Union one we can get, but Venmo is harder to get it from. And then, so the court specifically identified these three accounts, the Mountain American Credit Union account, the Venmo account, and the PayPal account. The Mountain American Credit Union, I assume we'd be able to get through a subpoena, but Venmo and PayPal are more difficult to get responses to a subpoena.
Okay, next question. Assuming that she does do it, how will you be able to know or verify that she's given you the complete account information?
That is a good question, Your Honor. And that leads me to my specific point about why terminating sanctions are appropriate here, because there's no way for us to ever know. These are things that we know she withheld because we found out about them in references to other documents, but we'll never know what other evidence she concealed, what other evidence she didn't include in her responses to discovery, other evidence that is relevant to this. It is impossible for us to have a fair trial on the merits when she's concealing evidence and only disclosing the fact that evidence exists after we find something that shows that it exists. And then after we find something that shows that it exists, she deletes it or allows it to be deleted. And under Utah law, there's a case, it's Macris versus Sevilla. It's included in...
My case, I did it.
Oh, well,
In case you didn't
I should have looked more carefully at this. But it is a very well-written opinion that talks about how in instances like this, that someone who conceals evidence, who allows evidence to be spoliated, who doesn't comply with the court's orders, repeated court's orders, undermines and erodes the public confidence in the judicial system. And that is exactly what would happen here if we were forced to go forward in this case, knowing that she's spoliating evidence, withholding evidence, concealing evidence, and repeatedly not listening to the court's orders.
That case was a little different in part because the individuals in that case went down to the office where the business is operated in the dead of night, loaded up all the equipment, all the office documents, office supplies, and drove them to Texas, took them outside of the jurisdiction of the state. So, I am familiar with spoliation attempts and the attempts to hide evidence and put it on the breach of other individuals. So that's a part of it. And I said I wanted to know what information was being taken or not provided in order to see and justify the potential sanctions and what the conduct was of the party to be able to do it. Now, last question. Do you have these attachments that you're showing me on the screen as part of your motion?
I believe most of them are, but there may be a few that have not. So this entire, and we'll put it on a thumb drive so you can have every slide that we've referenced in my argument, if that would be helpful to Your Honor.
Okay. Thank you. Anything else?
Not unless you have any questions, Your Honor.
Does anybody have any objections if maybe we take a short 5-minute restroom break? Because I know I've been pushing you nonstop for more than several hours now. Is that okay?
Yeah, that's
All right, let's take a short recess. We'll be back in 5 minutes, okay?
Let's go
Okay.
No.
Okay. Let's go ahead then and have you raise your hand. We're going to have you sworn and placed under oath before we go ahead and proceed.
Do Do you affirm that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
Thank you. Now, you filed a petition asking to have your name changed. Now that you are sworn and placed under oath, will you tell the court for the record why it is you desire to change your name?
I would like to change my name because to my mom's last name because my dad has not been in the picture for a long time, and so I don't want his name on my birth certificate anymore.
Okay. Are you currently married or have any children who would be impacted by your name change?
I am married. I have 3 kids. I don't know how it would impact them. They're currently with my married last name, which is Hanson.
Okay, so you're looking
On there.
only to change your birth certificate name?
Yeah, so on my birth certificate, my maiden last name is...
Go ahead. I don't know if we can just change your birth certificate name without changing your current name. I've never come across that. Okay? Does that make sense?
Kind of. So you mean current name as in my married name?
Yeah, exactly. A name change is to change your name. And normally when a name change occurs, it changes everything. We have people go back, change their name on their birth certificate, their passports, their social security numbers, their bank cards, their driver's licenses. Everything becomes changed. Okay? And you're not asking me to change your name, essentially. You're asking to change and modify an official record by trying to do that through a name change. And so, Ms. Hanson, I don't know if that's possible, okay? So here's what we need to do, okay? Let's go ahead and we'll adjourn this hearing today, and I will find out if that is something that can be done. And then we will contact you and either set up another hearing to complete the name change if we can, or we can talk about what other manners maybe you can change and modify your birth certificate without changing your name. Because I just don't know. Is that fair?
Yeah, that's very fair. I just
Okay.
wasn't sure how to, yeah.
So maybe what you can do, I don't know, if you contact the people in charge of your birth certificates, they'll probably just give you a layperson's response. We can't change your birth certificate without a court order and a name change. I don't know.
Yeah, that's what they told me.
Oh, they are, okay, yeah, I suspected, so. You see what I'm struggling with here? You're not really asking me to change your name, but to change a record.
Yeah.
So, I don't know.
Oh, okay.
Okay? So, let us get back with you on it, and we'll give you, we've got your contact information, so we'll give you a call. It will be just a day or two, okay? All right.
Sounds great. And I have one more. I apologize. I'm just not familiar with. If I did the name change with my social security card, would that be changed to my married last name, or is that's a different question than the birth certificate?
Yeah, it's normally your social security card and your driver's license and all your other documentation has to match up with your current name, current identification.
Okay.
Right? So sometimes, that's just the direction we're gonna have to go, okay? I'm sorry, it's a unique question. We've got a lot of smart counsel here in court, as you can probably see. I don't think they know the answer either. So,
The one we were just doing. What
okay.
date was that?
Well, thank you, and you're free to go ahead and go. We'll be in contact. If you don't hear anything in a few days, please feel free to call my court clerks, okay? All right, thank you. All right, let's go ahead and go back on the record and return to case number 230900882. Ms. Kamp, please, your response, please. If you want to stay there, you can. If you want to come up because you have the computer on the table, it's easier. That's fine too. Whatever you're comfortable with, is fine.
Sorry. I'm trying to get my Wi-Fi to connect again.
Good luck.
I'm using my phone now. Just because I wasn't prepared for this one today, but I'm happy to do it. Let's see. Okay. Did you say you were going to read this?
Yes, because
Okay.
it was just given to me. My course of practice is to read all motions and actually even start tentatively drafting decisions in draft form before a hearing on the motion. And then we go to the hearing, I hear the arguments, and then I finalize my decision in writing and send it out. As this one just came in yesterday, and I knew we were having a hearing today, I briefly took a quick look at it, but I did not read it in detail.
Okay. Do you need...
So I'm going to, after you give me the arguments, I'm going to go back and reread it, and I'm going to also work on it with my law clerk.
Okay.
I have a law clerk that's assigned to me, and then we will write up a decision. Now, this spoliation in the McChrist case that counsel was talking about, besides them packing everything up, is they have things on their computer. And I ordered them to produce the computer information. They went and they deleted their computer data and information because the hard drives, because it contained sensitive pictures with them and their spouse, and they didn't want the court to be able to see those pictures. But the point is they deleted the evidence and the information even after they were told that they needed to produce it. So the concern we have here is the bank records that you redacted. I know you've given something, but that something doesn't necessarily comply with what you were asked to do. So do you want to tell me, why don't you just respond to?
Yeah. Should I respond to everything that
Yes,
they... Okay.
because this could have severe consequences for you.
Let me grab my pencil. Okay. Starting at more the beginning of what they said, talking about when they pulled up on the screen, they had many different times when I had talked about podcasts. What they were trying to show there is they were saying was all talking about one podcast. And the problem I'm having with Jenn Kamp is that she speaks about a 2-part podcast, or like the podcast with my husband, interchangeably. And they're not interchangeable. They're two entirely different things. So when she brings up those things listed there on the board, those aren't me talking about one podcast. Those are multiple podcasts and answers to different things. But the problem that I'm having is she interchanges the two words, and then when I answer her, and then I found out, oh, she meant the other podcast, it's confusing to me, and I don't know what she's talking about. And so I'm happy to clarify which podcast I'm talking about in each of those things, but they're not the same podcast as she presented to you today. My husband and I recorded a very short podcast saying goodbye to the post-Mormon community. It was a podcast that was extremely short, just saying goodbye. I was closing down my podcast. I wasn't going to do it anymore. That's the gist of it, saying goodbye. I hope we can still be friends. Love y'all. That is the podcast with my husband. That has nothing to do with this case at all. That's why it wasn't produced. That's why it wasn't put on the paper. It has nothing to do with it. The 2-part podcast that I spoke about was that 6-hour podcast that I've produced to them. And I was going to follow it up because I only got to number like 74 when I was reading the podcast that their retained lawyer did a podcast about. He podcasted this whole lawsuit. And so when I heard that he had done that, I then did a response to his podcast. And in the response to his podcast, which is the 6-hour podcast that they're naming it, I went over the whole lawsuit number by number. And I was explaining my recollection and my version of what happened. Because there's things in there that I was not okay with a retained lawyer speaking about, and basically being the mouthpiece for them publicly while they pretend to be being quiet. So that was me responding, though I never published it. It was never uploaded. It was never edited. It was never looked at. It was never given to anyone else. It was never nothing. But they had me, because of your ruling, go back in, find the podcast, upload it, give it to them so that they could watch it, which I'm totally fine. I didn't care. As soon as it was ruled upon, that's what I did. So I don't care. I still stand by everything I said in that podcast. It doesn't matter to me that they have it. That's the difference, is she's trying to use 2 different podcasts in what she's trying to give you as her evidence. And it's not the same thing. And I'm responding to different things. So that's that. The 2-part podcast was never uploaded, never produced. I have produced it because you told me to. Now addressing the badass bitches. I just want to address this podcast because, text thread, because they keep bringing it up. Badass bitches was not called badass bitches to begin with. It's just a group of friends, like 6 women that I'm friends with. We were all going away on a girls' weekend together, and we made this group text message 3 months before I was even fired. Like, it's been going on for a long time, this group of friends, before all of this. And someone changed the name of it, and we all laughed about it, and we just kept it up because it was funny. At least to us at the time. This group chat, like I said, was, yes, there's donors in it, because all of us met each other at these events that are thrown by the plaintiff and the other plaintiff that's not here right now. We met at some of these events, and so they are donors of him, but they're also my good friends that I go on trips with and are my friends. So yes, we talk about things in them, and yes, we talk about things just friends talk about. The things that were shown as unsent, not deleted, but unsent, are things that I wrote.
Hold on, so you say not deleted, are you inferring they're recoverable?
No, I've tried and they're not recoverable, okay. The things that are unsent.
So they're deleted?
Right, yeah, but they weren't, yes.
They're unsent and not recoverable.
Not important either.
You did that?
Yes.
Okay.
But I also did that within with Facebook Messenger, which I had prepared. I can send you after. On Facebook Messenger, you have to unsend something within, I believe, 10 minutes of sending it, or else that option is gone. So those things that I unsent were sent at the very most 10 minutes after I sent them. So whatever that was, whether I made a mistake in spelling, or like I said something and then I'm like, I don't want to talk about that really. Like, I do it all the time. If I misspell something, I misspell things all the time. I'll just unsend it and then I'll retype it. It's not something deviously done to like not produce something. It's done 10 minutes after I sent it, whenever those were, like last September or June, whenever those were sent. I don't know. I don't have that with me when they were sent. But they had to have been unsent within 10 minutes. Now addressing I don't know what else to address with the Waka thread, which I'm happy we're calling now. The Badass Bitches is now being called Waka thread by Jenn Kamp. That's the first time I've heard her call it just something different. But the Waka thread, I just want to reiterate, is my friends. And I stand by what I said in there. I stand by it being true. And that's all I want to say about that. Moving on to, they're saying that these podcasts that I didn't produce, one of them was seen by one person right after I posted it. And it was only seen, I didn't post it, sorry. I uploaded it. It was accidentally put onto a playlist in YouTube, and I did not know when you added it to a playlist, it automatically made it public, even though it's uploaded as private. When I saw this comment come in, which I did produce to them, I produced the comment, so they knew that that happened. When I saw that this happened, I quickly took it off of there and then let my legal team know that that had happened. And I've given them analytics for that video, so they know that it was only me and my legal team and that one person that has seen the video. It wasn't up for many months. It wasn't even up for minutes. It was just an accident and one person saw it. And I'm also going to say that it's okay with me that one person saw it because there's nothing defamatory in it. But I did produce that. I didn't hide that. And when you asked me to produce it, I produced it. Ms. Tomczyk, sorry, I wrote that down, but I've already spoken to you about that, how she's mingling them together. And so I don't know exactly what she's talking about when she asks me questions. Talking about the bank statements. Let's talk about bank statements for a minute. The bank statements are a downloaded statement. That's how my bank statements look. You go onto the website, Mountain America Credit Union, you download your bank statement. It comes through as a CSV file. A CSV file looks like a spreadsheet, looks like an Excel spreadsheet. It's downloaded that way. There's transaction numbers next to the amounts that they could verify with Mountain America Credit Union to see where they came from. And I've also produced.
I thought the ones they were showing me were blank.
No, well, that's Hepworth when they sent them to them. That's because I've only made $940 off my podcast at all, ever. $940, both podcasts.
The point was you were to send them unredacted, were you not?
I didn't. Okay, so my understanding was that I had to produce the documents with all of the transactions that it has anything to do with my podcast or them in any way. I also use that as a personal.
Unredacted.
Right, and I gave them the transaction numbers, I gave them the amounts, I gave them, it's all listed there in those things. I know that the last 2 pages look like nothing, but you have to scroll up because I don't know why Hepworth added the last 2 pages that didn't have any information, but if you scroll up, you can see the name of the place, you can see the amount, you can see the transaction number from Mountain America Credit Union, all that information is there.
So you're telling me nothing was redacted from your bank accounts and that the pages that were put in there by your attorneys are just...
No, they're redacted all for personal things.
Okay.
Everything related to this case, Hepworth did not redact. It's there visible for them to see with a transaction number from Mountain America Credit Union. So I gave that to my lawyer at the very beginning, whenever that was, March of last year. So that has been given and produced by me, not withheld ever.
What about since the order that I gave? Did you produce it unredacted?
Well, she said to produce it or give her the Bates numbers. And so I gave her the Bates numbers
I
for...
didn't produce a new one unredacted since my order.
No, I didn't understand what you were stating, that my personal information is unredacted. Why would that be? Why when they don't have to produce any statement?
Unredacted simply means nothing covered up or hidden. That's what it means.
Why would I need to produce that?
Because that's what the court ordered.
Okay.
We want to know if you were hiding any income by redacting.
Okay, feel free.
Unredacted means unredacted.
I know that they have been podcasting and telling people that I've had $20,000 given to me or whatever, but
Okay.
That's fine with me. I'm not hiding any money, so feel free.
That's all I want to verify.
Okay. But that seems kind of...
Okay, let's move on. We've already got you. This is their motion.
Okay. Can I ask, though, why...
No.
Can I ask why I'm to produce unredacted things and not them?
This is their motion. You need to respond to what their arguments are. Is that you haven't complied with the court order and you should be sanctioned.
Okay.
And if your response is because you didn't do that same ruling for me, Judge, then fine. Tell me. That's your justification for not providing it. I don't know why you didn't provide it.
I guess I misunderstood you. I just thought that the transactions were unredacted. So they could look up the transaction numbers, they could ask Mountain America regarding them, and I gave them the Bates stamps and I didn't hear differently.
Okay. Thank you. Okay, any other response to their motion?
Yes. Regarding WACA, I know, but they also said that I did not give it to them. So I wanted to say that I did give them a screenshot of my encrypted message. When I went to get that evidence for them, my messenger said that whole thread was encrypted. So I texted within the thread, which they have the evidence of, asking the other ladies, I'm like, is yours encrypted? I came back here to get this to show the court, and it is encrypted. Is yours encrypted? Some of them said that theirs wasn't, and some of them said that theirs was. So I asked the ones that said that theirs was not encrypted to send me them. They refused. I begged them for them. They again refused. And I said, I don't know why you guys are doing this to me. Like, I have to produce them. They've asked for them. I told you that I would not produce them until the court or them asked for them, you know? But I did give them that evidence that it did exist from the very beginning. So when they asked for that thread, like me to go and try my best to get it. Like they asked, go see if Facebook will give it to you. See if you can get it from someone else. That's what I did. And I asked them all, and I begged them, and you can see it in the words.
Did you report that back to Ms. Township?
Yes, I did. Okay. And I gave them screenshots of it. So I then, months later, like, I think it was October when it was sent. I can't even remember, to be honest. It was sent months later to me by one of the women who finally decided to send it to me. One of the ones that was not redacted. Because after they wouldn't give it to me, I told them I didn't feel safe.
So you had it?
Yeah, so I had it.
Did you do it?
I did, yes. I produced it to them. And I actually produced it to Hepworth. And Hepworth, I assumed, produced it to them. Then months later, when we are having our, I think in the meet and confer, where I answered questions for them for an hour and 20 minutes. And then when I asked her a question, she said she wasn't going to answer any for me.
You're missing the point.
I'm just saying, I gave them, as soon as I knew she didn't have that from Hepworth, I sent it again to her.
You did. So you did or you did not send it yourself to her, the complete
I did, yes.
chain?
I did, complete chain. So I just wanted to clear that up, because I wasn't withholding anything.
We're talking about the unsend,
That same thread.
the same thread.
Yep.
Okay.
Mm-hmm. Sorry, personally, I don't know. I just want to say this last part. To me, this is another extension of the abuse that I had from him. This whole litigation process and putting me through this. I feel like if I'm held to the standard of, oh, I don't have that anymore, I didn't mean to not have it anymore, but I don't. Like what they're saying with the surveillance video, right? They just pulled up that statement from my lawyer that said on September 15th, keep all evidence. So if I go September 15th, back 2 weeks that they're saying that their surveillance camera footage only lasts, then they should have everything from August 25th forward, which they have not produced to me.
Has somebody sent them a demand letter that they preserve and keep the evidence as they did to you?
They showed it in court today to you.
I thought that was their letter.
No, that is my letter to them. I was suing them.
I don't recall seeing that.
Yeah, they pulled it up on the screen. It was Chris Snow. That's my lawyer.
Counselor, is this-
There are two letters. One is the September 15th letter where her counsel talks about the preservation obligations in the case. And then there's the October 28th one where we say, look, you're the one who told us to preserve all of this, and we have evidence to show that she's spoliating evidence. You need to preserve it.
What about the preserving of the surveillance video?
It doesn't specifically say surveillance, but remember that the Cove policy said 7 days. So September 15th is long past the 7 days. I believe the last time Ms. Kamp was ever even in the office was August 22nd. Is that right?
You came in to collect your stuff.
I came in for a meeting on the 25th,
Okay.
and I came in to collect my stuff.
Thank you. What else? Anything else on that? Or we give them the final say?
Yes. Again, I would argue that I've asked for their bank statements. They haven't produced them.
Your issue of compelling has nothing to do with the motion that we're dealing with.
Okay.
You need to separate that out.
Okay.
One doesn't have anything to do with the other.
Okay, so I would also want to address the donors that they're talking about. I've asked for a list of donors that they're saying stopped donations because of what I said, whether it be in that text message they just showed or the video that I produced with names and contact information and the amount of the donation that they're saying they did not produce. Yeah, have not produced that yet. So I need to be able to talk to the people and see if it's because of what I said or if it's the pattern of abuse and harm they're seeing by John Dehlin as the reason that they stopped their donations. I should be able to contact them and ask them if it was me that they stopped their donations or if it was a different reason that they stopped their donations. And I haven't been given that, and I've asked
I
it.
don't think they've asked you to give them the reasons why they stopped. They just want to know who stopped, right?
But
Who stopped?
it depends.
No. Who stopped? Who didn't? This is the second question. Why did you stop? I don't know that they asked you to provide them information why they stopped viewing your channel. Did you?
I'm not sure I understand what
Yeah.
Aren't you just seeking how many donors stopped contributing or attending her channels and so forth?
we're looking at the overall, or we're talking about bank statements. We're looking at the overall contributions. So there are three claims that we've made. One of them is trademark infringement along with defamation. We're looking to see who was contributing money to her podcast based on her trademark infringement and also on the defamatory statements that she made.
But you're looking to find out who no longer contributes or who no longer subscribes to her channel, right? Isn't that what you were telling me?
But my understanding,
to John's channel?
People to find out why they were no longer involved?
well, my understanding is they're suing, or they're suing me because of people they say have stopped donating because of me. That's what is in this trial. That's what's in their case, is that specific people who used to donate to them, when they saw my podcast, stopped donating to them. So I need a list of the people who they're saying stopped donating to them so that I can...
This is your discovery request again for this.
I have. That's what I'm saying, and you have denied it.
So why are we talking about it?
Because it's so important. You're giving me nothing to defend myself with.
Okay.
How? You tell me, how am I supposed to defend myself when I am not allowed to get anything in it? How? Tell me how.
I can't give you legal advice, except for you to follow the rules.
I did follow the rules.
Okay, well, we're not going there again. Do you have anything else in regards to their response for their sanctions against you for items that you have not produced or that you have spoiled? That's what we're dealing with right now in this motion. I want to make sure you...
I've given them everything they've asked for.
Okay. Thank you.
Thank you.
Response, Ms. Tomczyk?
Thank you, Your Honor. And I'll try to not jump around here, but the argument jumped around a bit, so I'm trying to be as succinct as possible. I think that the argument that we just heard just further demonstrates that Ms. Kamp is willing to say whatever she needs to say to help her at any given moment, and it's not always consistent with what she said in the past. We've already showed you the evidence of how her stories changed with respect to the recording that she made with Mr. Kamp. And I want to point out 2 points.
What about the confusions? She's claiming you're
Sure.
confused between the two videos.
Sure.
So address that.
Exactly. So the first thing I want to show you is slide number 40. This is the text that she exchanged with one of OSF's donors talking about exactly what her what this recording was. Sorry, this is not slide number 40. So her description contemporaneously with when she recorded it is that it was a little goodbye and then her responding to the countersuit. So she specifically she's talking about Jason and I did one together. So that description of her recording is inconsistent with what she just told the court what the recording was about.
You have to read the next sentence, though.
Hold on. Proper procedure is you don't interrupt the other person when they're talking. Ms. Tomchak isn't going to interrupt you. You can have a chance to say that it's there. If you think that the next sentence shall be on it, point it out when it's your opportunity.
Okay.
But beyond that, Your Honor, the point with the recording being missing, she can claim right now that it's about whatever she wants to claim because she let it be deleted. And she's the one who has to suffer the consequence of deleting the evidence that we now can't test the veracity of what this recording was about.
What about the confusion between two podcasts?
Sure. So I think what she was arguing there was that when she said we never recorded it, she was talking about a different podcast than the podcast with her husband. And we recorded and we agreed that we were recording the meet and confer. And I have specifically what she said to me during the meet and confer about this recording. I believe that is, do you have the slide, Gerardo? Okay, if you'll go ahead and play that, thank you.
Well, this isn't explaining to me whether or not you were confused between two different podcasts.
My understanding of what she was arguing, Your Honor, and this does, I think, explain it, unless I've misunderstood her again, is that when I pointed to the court to say, look, here's her saying, it's private, I'm not producing it, it's private, then, oh, just kidding, we never recorded it, and then just kidding, we deleted it, is she's saying I was confusing when she said we never recorded it. But you can see here with the highlighted language from our meet and confer, she said, I don't even know if my husband and I ever actually recorded that. Recorded it. We talked about it, we wrote down things about it. So there was no confusion. She was very clear in our meet and confer conference that the podcast, the recording that she was saying that she wasn't sure they recorded was the one related to her husband. And that, as we see from the slide we just looked at with Ms. Sharp, an OSF donor, she said specifically that she recorded it. And now she's saying, well, just kidding, we deleted it. Oh, just kidding, something else deleted it. I mean, the point being that she's the one who allowed it to be deleted. She's the one who should suffer the consequence of it being deleted. It's clearly relevant and clearly occurred at a time when she had an obligation to preserve the evidence. And it calls into question what other evidence has she withheld, whatever evidence has been spoliated. With respect to the WACA threat, there were a number of things that I wanted to say about that. One is that her statement that you can only delete things from Facebook within 10 minutes just isn't true.
Not Facebook. She was referring to her text message.
It's Facebook Messenger and it's unsent, not delete. You can delete anything at any time, but those show unsent. Unsent.
My understanding is that on Facebook Messenger you can also unsend them at any time. We can show you that, or you can have one of your clerks who has Facebook Messenger try it.
I believe I produced that in evidence.
Who knows? Is there? We can show anything.
We can show you right now unsending a message from before, or if one of your clerks has Facebook Messenger and they want to unsend a message. I think this is a red herring. Because regardless of we know for sure that she unsent it after September 15th. Because the messages occurred after September 15th. September 15th is when we had the preservation letter that said don't delete anything. So she knows as of at the latest September 15th that she should not be deleting her communications. And that's the very day that the communications are deleted. So even if she only undeleted things on September 15th, it's after the preservation letter has gone out. It looks like, if that were actually true, it looks like she went through and started deleting stuff right after her attorney told her it might be produced. So it's actually worse for her if you can only delete it within 10 minutes, because that suggests that she deleted it right after her attorney told her she had an obligation to preserve it.
Okay, what about her comments that I thought I heard her say And that is, she eventually was able to get the full, complete text chains of information.
I think-
The lady was sent first to her attorneys, and she wasn't sure it was Bruce, but then she said she did send that to you, that you had everything.
I think she misunderstood what you were asking. We do not have a complete text thread. Those unsent messages, we do not have a single one of the Rocket text thread that doesn't have the long list of unsent messages. And I do want to point out, Your Honor, okay.
Let's ask her if she has it. She told me that she did, or she's going to tell me it was a confusion. Do you have?
No, it was confusion. My text
It was
thread,
conditioned?
confusion. I said in what you asked, which I think she was confused at also. My text message thread was encrypted, so I did not have the text thread at all.
I know. And then you said you finally got some lady to tell you the information.
Yeah.
And you've sent that on the complete text message chain to her. You told me that. I heard it from you.
I was saying I received the text message thread from Gabby, and I produced that to them. No one's thread has that. I think we were both confused, so I just want to point that out. We were both confused at what you asked. And so what I heard is that my encrypted thread that I had no thread of at all
Okay.
was given to me by Gabby, and I produced what Gabby gave me.
And that included the blanks of showing.
That included what you see here.
The recall of the same. Okay. Thank you for clarifying that.
So we do not have the unsent messages. We've never had the unsent messages. She deleted them sometime after September 15th, after her duty to preserve.
Okay.
But one thing that I think is really important here, actually I want to correct one other thing that she said about it. This is a slide that shows what she was saying to the women about, may I approach, Your Honor?
You may.
I'd like to direct your attention to slide number 13.
Now, wait a minute.
I'm sorry. Page number 13.
Did I leave my pen up?
There's no way I can read. Small.
We have it on the screen.
You guys.
It takes me some trouble to.
Blow things up. Okay, where are we looking?
So, it's on on page number 13. It's the highlighted part, and it talks about what she's telling these women. And remember, again,
Makes 0587 for the record.
yes, and that's one that we produced. And I also want to point out that according to the metadata on the text thread that she produced to us, it was provided to her in October. And that's consistent with what she just told the court, but it was not produced to us until March. At least according to my records, we didn't get it until March
I meant 2022,
March 18th, 2024. So there's almost a 5-month gap between when she claimed she got it and when we actually got it. But so looking at this page 13,
Okay.
and in there she's talking about, and remember, this is approximately a week before her discovery responses are due. June 8th, she's talking to them and she says, I want this for myself.
Which one of the 6 am I looking at?
Sorry, it's the top left one. It starts with, I would like them for myself. So she's telling these women, I want copies of these texts for myself. So if evidence is suggested,
Start there.
Huh?
We're talking page 13 of 14, base 0587.
yes. And you see where the red starts? Do you see where the red starts?
No, because I'm colorblind.
Okay. Oh my goodness. Well, okay. Let me just summarize for you, Your Honor. Let me just summarize for you, and you can go back and look at
The first one
this.
says, if someone can send them, I would appreciate it. Is that where you're reading?
No. So
Oh, I would like them for myself. Okay, the
Okay.
box.
So if you look at the very end of that message, so it's on the next box, but at the very end, she says, this will always stay private as it should be. So she's basically telling them, hey, send me these, but I'm not going to produce them unless I have to. I'm going to keep these private. I'm not going to produce them. This is a week before her discovery responses are due, and she did not disclose the existence of this text thread in her discovery responses, as we've already discussed. Now, I said that it's a red herring because the major issue is that she unsent messages, but this is further evidence of her efforts to conceal relevant evidence, that she withheld it, she didn't even disclose that it existed, she didn't produce it. When she finally got it, she still didn't produce it. Finally, the court orders her to produce it, and when we get it, we see that she's deleted a bunch of the information on there in a context that suggests that it was defamatory statements that she was making about Mr. Dehlin. And I think something that's really important to remember here is that both with respect to the Jason recording and with respect to this Waka threat is that it shows a couple of things. In addition to showing that she tried to conceal them, but if the information was here, it would show us what she was saying to other people, not on her public podcast where she was presumably more careful, but what she was saying to them behind closed doors. And it would show what her version of the story was at the time that she exchanged these texts, because her version of the story has changed now so many times, and she's made new allegations and said more horrible and worse things have happened, and we should be entitled to see what she was telling people at the time she told them, and be able to discredit her current version of the story by pointing to the version that she was telling at that time. So this is critical evidence to our case. And
potentially, you also had the ability to interview and, I guess back to this, interview and depose the individuals themselves. What did she tell them?
And that's a possibility, but it will never be as credible as seeing what she said in her own words, especially where she's admitted these are her personal friends.
And memories fade.
And memories fade.
I know.
Yes, Your
But
Honor.
I'm saying the evidence isn't necessarily completely lost. It's just, I'm with you. But
Yeah.
in fact, discovery's closed. I get it.
Okay.
And if you had the information, you could
Right.
talk to them.
Right. And with respect to the bank statements, I mean, as the court's already noted, we're entitled to test the veracity of her statements about what she's received. She told us initially she hadn't received anything. We've now gotten evidence to show that she has received some things. But I think a really key point, she says, I didn't understand. We had a meet and confer. I explained to her, this is the court ordered that you provide unredacted statements. These are not unredacted statements.
Yeah, did it make a difference, though, between things relating to this case and things not relating to the...
No, because the court said bank
I
statements.
understand the difference between
Right.
unredacted, but she's trying to tell me that I should believe her, that she doesn't understand that she couldn't still cover some things up.
Right. Her attorneys are the ones who produced them originally, and you didn't allow them to redact them. So her counsel should have understood that. So at least the first violation of the court's order, that's not an excuse. With respect to the second violation of the court's order, you said it can't be an Excel spreadsheet. That's exactly what she produced. And you can download the actual bank statements from Mountain American Credit Union. You don't have to have this Excel spreadsheet. And in addition to that, the court specifically identified 3 different accounts. What she provided was 1 account. So there's still no excuse for her not to provide anything from the other 2 accounts that the court specifically identified. So I think...
Just before you sit down, before we lose that point, have you produced, or you have not produced the other 2 accounts, or you did?
I did.
Okay, where, when, how?
I put all the Bates numbers in the response to her in the email. They're all in line. They're all lined up right as they are.
But
There's
do you have the documents to show what you produced to her?
no, because I wasn't ready to talk about this one today, so I didn't bring them here. But
Do you have the complete set of documents she sent to your counsel?
I have exactly what she attached to her opposition that says these are all the things I produced, and that
they
there
weren't
is
attached to the
not
opposition. They were emailed to her when you asked me to email
Yeah, okay.
them.
there is not a bank statement from PayPal or any statement from PayPal. There are some screenshots of certain transactions, but no statements, and the same with Venmo. Nowhere in the production to us, and nowhere in her opposition where she attached the evidence that she claimed was responsive is there a statement from PayPal or for Venmo.
Okay.
Okay. So I just want to, I think I probably haven't covered everything, but I think I've covered enough. And I just want to say the court has very broad discretion in tailoring a consequence that doesn't just ameliorate the harm that was caused by her spoliation of evidence, but also to deter future conduct and maintain public confidence in trials. It should not go without consequence that she's concealed evidence, that she's withheld evidence, that she's repeatedly violated the court's orders, even after the court warned her that it would consider spoliation sanctions if she didn't respond to the court's order. And she's done it in a manner that we will never truly know everything that she's withheld. I believe the evidence indicates that she's been untruthful with the court, both in her affidavits that she's filed with the court and in the statements that she's made to the court and to counsel. I think there's very strong evidence in our motions and in what we've shown the court today, and that is something the court should take very seriously. We've asked for the court to consider various sanctions. I believe attorney's fees would be appropriate because we've spent time and resources to discover the existence of documents that she should have disclosed and to get copies of those documents that she now claims are deleted. We've also asked for a forensic expert to take her devices and review them to see if it can recover any of the spoliated evidence at her cost, because that's the only way we'll even know whether she's provided a complete production. We have offered as an option for the court an adverse inference. The adverse inference would be that she did make defamatory statements, that she made them to OSF donors and other prominent members of the community, that she had no factual basis for the statements that she made or knew or should have known that they were untrue, and that numerous people believed her and it damaged plaintiffs. That's the adverse inference that we've asked for. But again, I don't think that's enough in this case, given the repeated misconduct and the fact that whether it was intentional or inadvertent, and I think the evidence strongly suggests that it was intentional, that she allowed evidence to be spoliated that was relevant to this case, and no adverse inference will accurately or adequately convey that to a jury. That's why we think terminating sanctions are appropriate here. If this isn't one time, this is many times, and it's over a course of times, and she's continued to violate the court's orders.
So what are you saying the extent of the terminating sanctions should be?
That the court enter judgment in our favor and hold an evidentiary trial just on damages. That it strikes her defenses. Allowing a party to act like this in such a manner repeatedly without consequence will do exactly what this court recognized in Macros: degrade public confidence in the judicial system and in any result issued in this case. Thank you, Your Honor.
You won't get it, but I'll let you have it. 30 seconds, a minute, final words or thoughts on what counsel was suggesting for your sanctions, if any are opposed, or any other further response she has.
Yeah. One correction was that it was March of 2022 when I produced that to my lawyer, not March 2023, 2023, not March 2024, like she said. I've provided, for me, and what I understood to be provided, I have provided everything asked of me to the plaintiffs. It's become a pattern, what I have seen, in them giving evidence to you, to show you things, that they will circle or clip out or highlight what they want you to see, and not the next few sentences that say the rest of the story, that would make what they said entirely false.
And that's your responsibility. That is your obligation as counsel for yourself to point out the rest of the story or the other things that show or reflect light upon the things that they have submitted to the court. So you can't try to put blame on them for that, because that's the way that it is done, the process.
Okay.
That's what you're to do.
Okay.
And you didn't do in your responses, but we're giving you the chance today in your argument here. Anything else?
Yes.
Okay, briefly.
Well,
We've gone on 2 hours longer than I had
if
expected.
I don't know how I can briefly do this because I was just given this, but like 2 minutes ago by them. But I would just ask you to whatever they have circled to maybe read a few sentences down from what they have said. They also did this, and this is a pattern. This is all I'm saying to you, is it's a pattern that I see when they were deposing Amy Grubbs. They told her that I had said to them in my deposition that that she was working with me, and I had told them that she was working with me, and all these women were working with me. And that is exactly opposite of what I said. If you go down one more sentence from what she asked and you read the next paragraph, I say, if what you're asking me is that these women have worked with me and this was all put together and I have worked with them, then you are entirely wrong. It was me. This is my statement. This is my story, and I am enough. That is what I said. But when they show you, when they give you the little one sentence redacted little thing, they give you one sentence and they don't provide exactly what I said. And it's over and over and over and over in all these statements, and then they put it in their proposed orders. And then I feel like you read the proposed orders and you don't read the evidence that I give you. And I know I'm repeating myself, I understand. But I know that this is the last moment I get to say something to you, so I just want to make you aware.
Thank you. Counsel, anything else before we adjourn for today?
We do have her motion for sanctions that I think we already heard, but I just want to confirm that you're going to issue a ruling on that so we don't have to respond.
Yeah, work the list. No, I don't. I'm kind of convinced it was the raw video, the surveillance camera, the subpoenas, that's motions denied for the various reasons already set forth. It's one, old; two, untimely; three, it hasn't been done. I think, was this the one that didn't have the request to submit on it?
It hasn't been fully briefed yet.
Fully briefed. Okay. Well,
Can you take a look at the surveillance part of that motion? Because I feel like them spoliating the week of surveillance that they should have is the same spoliation that they're...
I don't think you're correct. They've told us here, all of us, and they've made representations on the record. The surveillance video does not exist for the dates that you wanted. So there's no information to provide to you. There's none.
And you're going to give me that same courtesy of the things that I say are not there anymore?
It depends. Okay. Frankly, I'm just going to be very candid. I'm having a challenge trying to decide how much I believe you. I'm having a challenge trying to decide how much of your response and your actions, this manner, the way that you've conducted the discovery and the responses, the filing of your motions, etc., is based upon ignorance and lack of understanding of how to handle these things by not being a lawyer versus taking actions or steps to not provide the information or not make it available. You generally judge people based upon the things that they say and what they do. And the severe inconsistencies in your position in responding to things causes a lot of concern, frankly. I don't see a great deal of candor. I don't see a great deal of forthrightness
Where though?
in providing, and we're not having a discussion. I'm
Sorry.
just telling you my thoughts.
Okay.
In weighing your believability. Okay? Okay? So, I struggle with your information. I struggle with the things that you've done, and I struggle with the way that you respond. Frankly. Okay? So, Counsel, you can.
Can I say something to you?
No, we're done. We've gone way over. You're not, this isn't trial. Okay,
Right.
we're done for today.
Just for housekeeping.
Yes.
Do you want us to prepare, oh, sorry.
I was just going there. Why don't you tell me what you think I want you to prepare a draft on to submit?
Okay, I believe a draft on the denial of the expert extension and the motion, her motion for spoliations. We have a prepared order for the privilege waiver. If the court would like a copy of that, we brought a copy, or we could submit it again. I don't think you've made a ruling on that, but we can provide you with a prepared order.
I have made a ruling on it.
Oh, you have?
As I
Wonderful.
told you before, I read the memos, I start drafting on it, I hold arguments, I hear if I need to change or change my mind or any decisions on the rulings before I issue it. So I have a draft ready to go. So I'm going to revisit it and then I'll issue it.
Okay.
So no, you don't need to prepare anything for my signature on this one.
Okay, and the attorney's fees you've already,
Yes, already done and signed.
okay, great.
And I've done also the item on
He hasn't ruled on that.
the overlay brief is included in this one. Okay? The one that I'm debating is, and frankly, I think it should be reciprocal. I would like you both to prepare your proposed orders on this last motion that we have heard for the last hour plus, and include, okay, and Ms. Kamp, this is for you, and include as attachments the exhibit or the information that backs up your story. In particular, if you're claiming something was left out or not provided, thus being distorted by counsel, which I don't find to be true so far. Okay, you've made those implications, but I don't see any evidence of that yet. So you'll get the opportunity to prepare your order that you think that I should sign based upon what's here. Ms. Ponchek, on yours, I want the attachments, I want the exhibits, I want it laid out with specific findings and specific connecting the dots. For the purposes, if this has to go up onto appeal, everybody will know exactly why and what the justification was and what the proof was to substantiate the decision. Okay?
Yes, Your Honor, I understand.
I would like, if you want, you can either send me paper copies, because I want to look at them as well, or you can do it on the computer chip if you want.
Okay.
Provide it to her as well, so she can see. Okay, and that'll give her the opportunity to potentially rebut with whatever she thinks she has, not just orally here, but with any backup proof that would substantiate her position. Okay? Anything else?
When I receive that from them, how long do I have to answer?
You start preparing your own.
Okay. But you said that I could rebut what they say.
Yeah, you exchange it within 7 days, right, to each other.
Okay.
Follow the rules. Any proposed order, you gotta submit to the other side, and they get 7 days to look at it. But you've got to do your own. Meaning, the ruling that you want me to make, with the backups, what was the proof, what was the evidence, what did it show? Okay?
The only other thing, Your Honor, is that there's a certificate of trial readiness due April 25th. I'm assuming since we've set a date that I don't need to do that.
If you want to file it just for the purposes of having a complete paper trail, that's fine. You were both in agreement today when for the record, to accept the trial date, just do it real quick. But we won't give you a
Okay, great. Thank you, Your Honor.
trial hearing. Okay. Nick, do you have anything? Do you need anything?
Just the last thing on Ms. Compton's preparing an order on the denial.
Both of them.
Well, what I'm saying, that's just
Oh,
draft
yes,
decision.
yes. Okay? All right.
Could I understand what you were just saying? Both of them? Like, am I responding to just one, or am I responding to multiple things? What he was just saying, sorry.
Well,
I think,
yes,
oh, sorry.
I'm happy to tell you what we're doing so you're not confused. Okay? I can't think of the rule number off the top of my head for a minute, but it essentially says when the person is asked to prepare an order for the court's signature, they're required to send it to the other side to look it over. 7 days. They have 7 days to file any objections relating to the order. Okay, this is very careful. The order being inaccurate of what the court ordered. Not objecting to what the order says because it didn't rule in your favor, or you can object if something was added in for the court to sign that I never said as part of the order. Okay, those kinds of things you can point out and object to. That's fine. If you don't have any objections to that order, then after 7 days, either party can submit it to the court for signature, because you've already had your time to oppose it. You've had the 7 days, and if you don't respond, it's assumed not to be objected to or opposed. The court will go ahead and sign it. That process is meant as a double check on counsel to make sure they don't include things that are inappropriate in the order, and that the order is accurately reflecting the judge's order on what they wanted done. Occasionally, counsel will try to slip in things into their orders and ask for things or additional comments or so forth that we never ruled on, we never decided, we never determined. Okay? That's the purpose of that ruling. Okay? If you think she's put anything in that's inappropriate or incorrect in the order, even though you don't agree with the order, okay, you have to let me know by filing your objection. Now, the second one on this motion we just heard is a different story. We're both asking you to prepare orders. Your version, and she'll prepare her version. Okay? And then you gotta send it to her. I don't care if you guys oppose each other's orders or not. To me, that's a waste of time because you're both telling me what you think it ought to be. Okay? So that's up to you. Okay? Thank you. If nobody has anything else, then I think we'll go ahead and be adjourned. I'll let you go with lunch.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
I think he wants.
Well, that concludes the 4-hour hearing that was held in the 3rd District Court in Salt Lake City on April 23rd, 2024 in front of Judge Faust. You've heard it here with your own ears. Once again, even though the judge did not rule on the motion regarding spousal immunity and attorney-client privilege, at this hearing, he did issue a written ruling subsequent to this hearing granting OSF's motion that the court find that Jenn Kamp had indeed waived both her attorney-client privilege as well as her spousal immunity, at least to the degree of the information that she did disclose, and any other issues or communications that might be involved around those conversations that she disclosed. The big question that we don't have the answer to is what the judge is going to rule on the third and final motion, the motion for spoliation, where Judge Faust is now going to have to rule what sanctions to impose upon Jenn Kamp for her spoliation of evidence. It seems pretty clear that he's going to find that she did spoliate evidence. The only question left is, what will the sanction be? Will it be a lighter sanction, or will it be the ultimate, most drastic and draconian sanction a court can issue? A sanction reserved only for the most extreme cases of spoliation of evidence, and that sanction is to find as a matter of law that the plaintiffs, OSF and John Dehlin, have been irreparably prejudiced in their ability to have a fair trial and present evidence because Jenn Kamp has been deleting it, getting rid of it, and hiding it. If the judge goes for the most extreme sanction, that means that he will simply find as a matter of law that Jenn Kamp defamed John Dehlin. There will be no jury trial on the issue. If the judge goes for the most extreme sanction, he will simply find that Jenn Kamp did defame John Dehlin, and then there will be one hearing, and it won't be on the issue of whether she defamed him, because that will already have been decided by the judge. The only issue then will be, what are the damages that she has to pay for the defamation? I will definitely keep my ear to the ground on this, and I will wait and watch for that order to be released by the judge. And once it comes out, I will definitely come on the air and share it with you. By the way, I have saved a special surprise for the end of this recording, and it's by way of a reward of sorts for those of you who managed to slog your way through the entire 4-hour plus hearing. In order to keep the record completely up to date, I will advise you at this point that last night at around 10:30 p.m. my time, I received a text. Yes, a text from Jenn Kamp. I have not heard from her for about 2 years, since her departure, at least, from Mormon Stories. And suddenly, I get a text from her. I'm going to read to you right now what it is that Jenn Kamp texted me last night at about 10:30. Last night being May 3rd, 2024. And the precise time of the text being 10:23 p.m. Pacific Time. And here it is. One day, ... when you actually sit down and hear my story and look at the evidence I have, period. New line. I hope you feel deeply the depth of harm you have caused. And then I hope you do better. That is the entirety of the text that I received last night from Jenn Kamp. So apparently, after trying to get me disbarred, Jenn Kamp is now going to try and guilt me into submission. Well, it doesn't look like either of those tactics are likely to work. Anyway, wanted to share that with you as a special bonus for those of you who made it all the way through the hearing. Thank you so much for listening tonight. Please hit like, please hit subscribe, and please stay tuned for the next update on this case. Well, that's about all for tonight. Until next time, this is Radio Free Mormon, signing off the air.